morning, Mr. Law. Good morning, Mr. Bodlani. Good morning, Advocate Johnson.
Morning, Chair. Morning,
Thank you.
Commissioners.
Good morning, Chair, and good morning, Mr. Bodlani and his team, and good morning, Advocate
Morning.
Johnson. Chair, I guess before we proceed with Advocate Johnson's testimony, it's necessary to take stock of where we were on Thursday when we parted. During the course of Advocate Johnson's testimony, certain documentation was requested, and we followed this up with a formal letter, just so we're all on the same page. I just want to confirm what we have received and haven't received, because that becomes relevant to how we conduct the leading of her testimony this morning. Commissioners, you are being provided with a copy of the letter that was written by the Commission on Thursday at the close of the hearing. Advocate Johnson, you do have a copy of the letter. Oh, you've been furnished with now. Over the course of the weekend, including this morning, we've been receiving documents. Just want to check what is still outstanding, what has been provided. So if we could have regard to page 2, item 2.1. Item 2.1 requested all documents related to and constituting the investigation record as per investigation reference number provided. Can we confirm if we have received that document? It would appear, or that file, it would appear that it's outstanding. Do you confirm?
I confirm that file is outstanding, yes.
Oh. Then 2.2, we requested relevant documentation for purposes of section 28, specifically that enabled IDEC to initiate investigations into the alleged misappropriation of the crime intelligence slush fund. On our record, that document too has not, that documentation hasn't been provided, am I correct?
We have provided, Advocate Maga, I believe we have provided a section 28.1.
For?
And that is the section 28.1 that we have.
Okay, let's just, and that is why this exercise is necessary. You recall, if we take a step back, your testimony is that Mr. Adams filed a section 27 in November 24, and that was followed up by engagements in January 25 to seek further clarification. And you indicated that the clarification sought and obtained in January 25, by then the investigation had broken into different legs.
Correct.
What we have been dealing with is the Mukwele leg, and I had understood you to say there are about, in total, 6 investigations flowing from the section 27. And one of the allegations advanced or suspicions expressed was that certain generals, mainly the 3 generals, General Kumalo, Lekalakala, the third one escapes me now, were misappropriating crime intelligence slush funds. That was a specific investigation as I understood it. So 2.2 requests documentation regarding that particular leg. And now I want to establish whether or not we have been provided. We've been provided with dockets from Cape Town and Pretoria. But I didn't understand the dockets to speak specifically to this, unless perhaps we didn't express ourselves in the clearest of terms.
Chair, the evidence leader did express herself clearly. The letter is clear. Perhaps to clarify, we have a section 28.1 with regards the slush fund council. That still is in the section 28.13, which had been provided.
Okay.
It is still in its investigation phase and had not moved into the section 28.1 phase,
Okay.
if I could clarify.
I confirm that what we have since received on that score then is the section 28.13 application.
That is correct.
And you say that this issue, what's reflected in 2.2 is part of that.
It is reflected in the 2813 from
Thank
my
you.
recollection, yes.
Then we get to 2.3, all relevant documentation. Yes, ma'am.
Sorry. 2.2 also refers to a Section 27 affidavit.
Yes. Yes. Thank you for pointing that out to me. Advocate Johnson, you hear Commissioner Baloy's clarification. There are actually two requests in that 2.2.
The only 27 we have is the Section 27, Commissioner Baloy, that was referred by Adams on the 21st of November, 2024.
Thank you, Commissioner Baloy.
I don't know if he uses the direct words, but we would see it in the 27. There isn't an additional one.
Thank you. Turning then to 2.3, this was documentation providing authorization for the investigation to the manipulation of security vetting process. We know that it's in the 27.
Correct.
But this specifically relates to unlawful issuing of security clearances in favor of certain persons within crime intelligence. So that you recall in the Mukwele matter, there is a complaint about manipulation of security vetting processes. But then it goes further to talk about recruitment and employment and manipulation in respect of other people besides Brigadier Mukwele. And that's what 2.3 sought to obtain.
That counsel should be in the docket that was provided, Brooklyn CAS 543 of 6/2025.
And for the record file 54306,
that matter is a matter that has not been, there's no CAS registered for it yet, Chair. It still operates under the CIN reference number. I think those are the documents, Council, that Advocate Maga would have sent through last night, where there were different volumes containing evidence and affidavits, which is a matter still under investigation. It is not a case.
okay. Just scroll back to 2.1, your 2.1. Are you saying that what's requested at 2.4 is part of that investigation, that big CIN number?
Yes, all of the matters, that was the only inquiry number that was opened.
Yes. And that record is still outstanding.
Yes,
So we can't gain any insight into what is requested at 2.4 until we get the inquiry file.
the inquiry file in 2.4 has been made available.
Okay?
So when I call it an inquiry, it contains evidence, Chair, it contains documentation. Because the investigation has not yet been finalized, it has not been registered as a docket. That is why it still operates under the CIN number, which in itself is an inquiry.
Also, but all information relating to the subject identified here is there and
Correct.
has been furnished, you say?
Correct, Chair.
Thank you.
I'll make a note of that. I'll come back to the issue shortly, Commissioners. Then lastly, we requested all A1 statements provided by Honorable Adams MP as of January 2025. And those A1s have been provided.
That is correct, Council. I obtained them from the investigating team on Friday. They gave me copies thereof. The copies have been handed as they were furnished.
Thank you.
I believe, unfortunately, and apologies, somewhat late yesterday evening.
Ms. Silo,
Yes, Chair.
didn't you, perhaps because of the reference to other than Brigadier Mukwele, which appears in 2.4, did you not as a result skip 2.5, which also has the other than Brigadier Mukwele?
Oh, yes, I apologize, I skipped that. I realized I skipped 2.5. Thank you for pointing it out, Chair.
Yes.
Yes, and Chair, that then would also relate to that inquiry file of 2.4. All those other appointments would form part of that file.
Thank you.
Hence, it was that many volumes that were supplied.
Most obliged. So then we've dealt with 2.4, 2.5, we're at 2.6, and it's all A1 statements provided by Mr. Adams as at January 25, however many there may be.
Correct. As I indicated, they said there were 4, there was 1 per docket, and in fact, I was given 4, which I then furnished.
Thank you. I think those were the documents we had requested as at close of business on Thursday. Commissioners, you have, unfortunately, a new file added, it's file 9. The index is being updated. These were documents that came in last night and this morning. And that file 9 should then contain the documents referenced in paragraph 2.6 of the letter. You do have file 9 with you, Advocate Johnson.
That is correct.
These are the documents as received from yourself from yesterday, and in fact, even file 8 has been updated. So file 8 has got additions. And all these are the documents that have been flowing over the course of the weekend in response to this letter. We, as the evidence leaders, need to apply our minds to file 9 to see the extent to which it answers the requests set out in the letter under reference. And that, of course, will impact our approach to her testimony. So we may have to stand down some issues until after tea while we wrap our minds around the new documents. Thank you. With that, I think we are ready then to pick up where we left off on Thursday. For that purpose, I would like you to have before you file 3. And at file 3, I would like us to go to page 936. This is the Section 28 summons issued and signed by you on the 6th of February 2025. The questions I'll be posing on this document could potentially be part answered by the A1 statements you received that you've provided in terms of the letter, all A1 statements issued by Mr. Adams.
Okay.
Could potentially be, but like I say, still have to consider the content. You, I assume, would have cast your eye on the A1 statements and are able to confirm whether or not the A1 statements provided lend us to where this Section 28 summons is. Are you with me?
I'm with you.
My view is that summons will only make sense if buttressed by a compliant Section 27, supplementary statements, and any other information available to the investigators as at the 6th of February to issue that summons. Would that be a logical?
It follows.
Thank you. Now, this document, the summons, if you go overleaf at 937, just above a signature there, above your name, which I think it's your signature, you do confirm.
Yes, ma'am.
The details of the matter are said to be as follows, I quote, "This investigation pertains to manipulation of security vetting processes which resulted in the unlawful issuing of security clearances in favor of personnel within the Division Crime Intelligence of the South African Service." End quote.
I see that.
At the time you signed these summons, what evidence did you have, as by you, of course, I mean collectively the institution IDEC, what evidence did IDEC have to even conclude that there had been manipulation of security vetting processes and unlawful issuing of security clearances in favor of anyone within crime intelligence?
According to me, it would have had to have been the Section 27 referral, and it would have had to have been the supplementary affidavits that had been taken in January of 2025.
And as we established last week, we know that our Section 27 only expresses a suspicion
Correct.
of the commission of this crime without any underlying facts to support such a suspicion. So the answer then must lie in the subsequent supplementaries that we were received.
Correct.
My question then is, what must the commission do if it lands at a position where the supplementary statements do not support a claim such as reflected here? That on reading both the Section 27 and the relevant supplementary statement, one cannot reasonably conclude that a crime such as reflected here has even been committed or contemplated.
So if it's not made out in the supplementary, because that is what the supplementary sought to do, then these become problematic,
Yes.
because one would have to go back to those A1s
Yes.
and see what was said for them to have compiled to ask for this information.
And then if we go overleaf at 938, and your summons does say the detail is contained in your annexure B, and that is at 938. There is that list of 7. And this summons effectively asks for complete applications for security clearances and vetting files for the officers listed therein, starting with General Kumalo, in respect of all the ranks he's held, starting with the Brigadier, Major General, and Lieutenant General. And the pattern repeats itself. Now, as we had this discussion last week, one can understand perhaps how General Kumalo is identified. I think he's mentioned by name in the Section 27 referral. So is General Lushaba and General Madondo. At this juncture in February, again, we have that problem of names that do not appear from documentation that IDEC has at the moment it takes this drastic step, appearing in such documents as these summonses. I know you've signed, and I take it you signed because you are the head of the institution, but the document, the summons would have been drafted for you.
Correct.
Who would have drafted these summons?
These would have been drafted by an investigator. It could have been Mr. Perama or Mr. Padiachi,
Okay.
and or perhaps Mr. Mansa.
Mr.?
Mansa, Mantsa.
Oh, Mansa.
As being those, as being some of the investigators at the time.
Now,
Sorry,
yes.
at the bottom, sorry, Chair, at the bottom of 936, it does say at the bottom, there was also one of the investigators assigned was Investigator Mlambo. So the inquiries to Senior Investigator Mlambo at the bottom of 936.
Oh, I see what you mean.
Yes,
Where it indicates to whom inquiries must be addressed.
yes.
Okay. So he also could potentially be one. Now, we have since come to learn that Brigadier Ngube at item 1.4 was involved in the panel that recommended the appointment chair.
Oh, yeah. May I just refer to the part just above your signature at 937. That's the part headed details of the matter or other information. Was that meant to capture what was to be investigated? Or why is that included there?
Chair, they include it in there so as not to have a generalized subpoena. Because if you issue it only with the introduction and the background, and then you're on 938, just have a list of requests, it must relate to something. So when it's put in there, that is what the investigators reflect.
That's, so am I correct to say it was meant to set out what's intended to be investigated?
That is correct.
Oh, okay. For the future, perhaps, for those who will be at IDEC, because the way it's captured, it says this investigation pertains to manipulation of security vetting processes, which resulted in the unlawful issuing of security clearances. It appears to be stating a fact instead of saying...
An allegation.
Yes. It's stating a fact as it is currently stated or set out there.
The point is noted.
Thank you.
Thank you, Chair. Staying then with this list, as I said, we've come to learn that Brigadier Ngube was part of the panel that interviewed and recommended Brigadier Mukwele for appointment. I think I've been making a mistake, which I would like to take opportunity to correct. 1.5, the Van Vuren referred to here, is a crime intelligence officer already within crime intelligence. It's not the Van Vuren that applied for the job with Mrs. Mukwele. So, at some point I concluded that it was one of the applicants, but judging by information on some other documents here, I think I'm wrong in that regard, and I'd like to take this opportunity to correct my error. You then have Brigadier Mukwele. The one name I haven't come across in this investigation is Brigadier D. Bobby. Do you know who that is and how she gets to be included in this list?
It could be that it is not a person who is being investigated, but a person to provide the documents having the, no, I haven't come across Bobby, because they read exactly the same as the other. Sorry, yes, it reads the same.
Now, as I suggested to you, it's likely, as you say, either Mr. Perumal, Mr. Padiech, Mr. Mancha, or Mr. Mlambo prepared this. What do you, as the ID, normally have before you to ensure that the summons that you authorize is supported by some level of evidence that entitle you, as IDEC, to investigate, in this case, these crime intelligence officers to this extent? Do you just take their word for it? Do they prepare a document for you? Do you have an opportunity to glance the inquiry file to account for each name that is listed here?
What ordinarily happens, Chair, is that the person who issues or drafts the summons would come and brief the ID on, we need to issue a summons to this person. Part of the investigation relates to the manipulation of the security vetting, and in our investigation we have identified what is required and from whom.
So, if I understand you correctly, when we do get that investigation file, we will have a clear understanding of the basis on which these officers were selected to be included in the summons, each one of them in turn.
It should.
Okay, because you say it should, you force me to run ahead, and if it doesn't, if when we do receive the file, we find that there is no basis for what is contained in Annex B against these officers, what does that mean for IDEC and the Commission and the law?
Well, first of all, IDEC would have to, the person who compiled the summons would have to indicate where they've got this from, if it's not in the file, and what was the base document upon which these names were extracted and or identified.
It can't.
The basis.
Continue.
Sorry, the basis on which the names were identified and the purpose for which they were identified.
It can't be that person only. It would have to be you as well. Ultimately, you are the person that authorized. Only your signature appears here, not this other person that you are referring to. So we, as we sit here, look to you to furnish the information that you say someone else would have to furnish.
I agree. Once the information is furnished, that we have to go through that information.
No, I think the question also is as at the time you signed, what was your understanding with regard to what Advocate Sillo is asking you about? Because as at the time you signed, your mind should have focused on the issue Advocate Sillo is raising, or not?
The issue I focused on, Chair, was the briefing by the investigator, indicating what was required and why and from whom. It was a briefing, and then I signed the subpoena.
Yes, but you accept that as you sign, you accept that you are satisfied with everything that's on here, including the annexures, that everything is what it should be, which is why you sign.
Correct.
All right, thank you.
So you did satisfy yourself that these names are correctly included in the summons?
I had no doubt sorry, my English escapes me. I had no doubt, I had no reason to doubt the briefing that was given to me by the investigator. So I didn't ask for a I didn't ask for a document. I was satisfied with the briefing that I was given. That as an investigation team, They identified that this is the investigation that is outstanding, this is what they require for the investigation, and this is what it is that must be subpoenaed.
It sounds slightly different to what you have just said to the chair. I'd understood you to mean you satisfied yourself that there is not a name in Annexure B that ought not to be there because either there is no evidence supporting it. So I thought you satisfied yourself. But sounds like I misunderstood you. What you mean is that you satisfied yourself that the investigator who put these names before you had done their work. You took their word for it, and that's how you satisfied yourself.
That is correct.
So you open yourself up because it's your signature that gives authority.
Correct.
You open yourself up for potential manipulation by some of your investigators because you trust them implicitly.
I take note.
Now, what do you suggest the commission must recommend? Yeah, apologies.
Before you get to the suggestion question, can I just understand this? You satisfied yourself, and I want to look at specifically this list. So let's look at 1.1, and I just want to understand what it means that you satisfied yourself. The request is based on that there was manipulation, if you go back the previous page, which resulted in unlawful issuing of security clearances. That is what you're investigating. Are you saying you were satisfied from the briefing you got that there was a basis to investigate whether General Khumalo, or an allegation that General Khumalo's security clearance given when he was a brigadier was a result of manipulation of your vetting process, of their vetting processes? When he became Major General, the security clearance that he got was a result of the manipulation of vetting processes. And then when he ultimately becomes I think he's a brigadier, major general, and then lieutenant general. Are you saying that with the briefing, you are satisfied that there is a basis to investigate those clearances that he got starting with brigadier? Is that what you satisfied yourself about, that there was a basis for that?
There was a basis.
For that.
To request those documents to determine whether or not, in fact, there was a manipulation of the security vetting process.
So you were satisfied that there is from your briefing, you were satisfied that there is sufficient information that casts doubt on his security vetting for all those three positions?
That is correct.
Okay, thank you. Thanks, Mr.
Thank you, Commissioner Baloy. And perhaps just to clarify, when Colonel Padiache appeared before the commission and was engaged on this document, he testified that his investigation was confined to the recommendation and appointment of Brigadier Mkwele. So that's the person appearing at 1.6. And he explained that this summons was intended to cover all other investigations. So he could not account for how the names of 1.1 to 1.5 and 1.7 found its way into this summons. His interest lies only in 1.6. You suggested that we should turn perhaps to Colonel Padiache, Mr. Perumal, Mr. Mancha, and Mr. Mlambo. On that basis, on the basis of what I have just highlighted, it would sound that Mr. Padiache, Colonel Padiache has given an account of this Section 28, and we cannot turn to him. Would there be a reason for you to question that he is correct, that he can only account for Brigadier Mkwele because that was the leg of the investigation he was involved in?
Chair, because they work as a team, you would find that they compile these subpoenas, and when they compile the subpoenas, they identify as a team what is required. As indicated initially, when the legs are broken up into different legs of investigation, they also would then, in the manner in which they subpoena documents, don't subpoena per individual, especially when you're subpoenaing, as an example, from the National Commissioner. They would want to subpoena as many of the similar types of documents. So he would have had to have been part of that conversation and would have had to know that all of these people are also being considered. It's a bit difficult to divorce yourself when you are part of a team, because on the basis of what would you say to Mr. Mlambo, whose name is on the... Mr. Mlambo, while you're doing this, just add my one. They would have to agree as a team. Vetting processes, this is what we're looking at. Who are we looking at? What are we requesting? Whom do we request it from? That makes sense in terms of their investigative methodology.
Okay, so then, if I understand you correctly, they bear collective responsibility for that list. It's not enough for Colonel Badiachi to say, I was only investigating the appointment of the person listed in item 1.6.
That is correct.
That's okay.
Sorry,
Yes,
before,
yes,
you,
Commissioner.
before you do your question again, just to make sure that we're not missing each other or you understand the fullness of what I was trying to do. I used 1.1 General Kumalo as just an example, but in fact, what I was raising applies to all of the people on the list. Can we confirm that your response applies to all of them as
That
well?
is correct.
Okay, thank you.
Commissioner Bala.
Yes, Commissioner.
Good morning, Advocate Johnson.
Good morning, Commissioner.
If you look at 937 and the offenses listed there, it is fraud and corruption in the bullet points, you see that?
I see that, Commissioner.
Yes, and then you go to Annexure B. Let's just focus on Major General Lushaba, for example. For the rank of Colonel, Brigadier, and Major General, was there Section 27 referral to IDEC suggesting that their vetting and clearances were tainted with fraud and corruption? Just focusing only on Major General Lushaba. Was there such a 27 referral suggesting that their vetting and clearances were tainted with fraud and corruption?
It was the generalized Section 27, Commissioner Kumalo, of Adams, of November, and we just need to check in the additional A1s that were taken, if they were expanded on in those A1s. But there was a generalized Section 27 referral.
Because my recollection of the Section 27 is that he was saying all the colonels in crime intelligence are not suitable. I don't remember seeing anywhere in that Section 27 where he says their security clearances and their vetting were tainted with fraud and corruption.
I would just have to...
If you go to file 2, page 512, CJC 373, that is the Section 27 affidavit by Mr. Adams.
Sorry, Council, the page reference.
512.
It starts on 512. If you look at paragraph 4 on 513, that is the general statement that is made. And it starts with the manipulation of procurement processes. And it lists the civilian who worked for BMW. And then the paragraph after that says it is concerning that out of all the colonels employed in crime intelligence, none of them were suitable to be appointed to this post. But I don't recall seeing in the referral anywhere where it says Major General Lushaba's vetting and clearance is tainted with fraud and corruption.
Sorry, Chair, if you just grant me a moment. Yes, yeah, correct, Commissioner Kumalo, that he just refers to processes to appoint and promote certain members.
So it is the Mukwele issue where the vetting is a problem. And then reference to Lushaba is in paragraph 6 on 514, is the issue of the housebreaking and the laptop.
That is correct.
But there is no referral relating to their vetting or their security clearance being tainted with fraud and corruption. So if that is so, would there be a legal basis for then investigating their vetting and security clearances at all 4 levels, or at 3, at the level of a colonel, brigadier, and major general?
Chair, it would depend on what else they did have access to at the time, because they would have had to have access to the additional A1 statements that were taken, and not just this. So I would be remiss if I say no. Because this is done, Chair, in February of 2025. By that stage, they would have had the engagements with Adams, and in terms of those additional statements, I'm not sure that additional documents were provided, but they would have had a twofold basis upon which.
But as I understand it, the substance of what Commissioner Kumalo is raising with you is this. If this was never referred in terms of the affidavit, how do we suddenly have it here? The fact that the investigators may have come across some information at a later stage cannot cure the lack of a referral in the first instance. I thought that's the substance of the question.
Correct, yes. And so we would just have to look at the additional A1, and because the additional A1 is supposed to talk to the Section 27, if it is not there, then it doesn't talk to.
So even if the information is subsequently obtained and is contained somewhere, it means nothing if there was no referral in the first place, or not?
Unless there was other evidence before the issue of the summons.
Yeah, okay, all right, okay.
Thank you, Commissioners. So, when we do look at file 9, which is where the additional statements are by Mr. Adams, what do you suggest what conclusions do you suggest the Commission must draw if this Section 28 is not supported, in its terms, is not supported by the A1s? Oh, please, so apologies. Sorry, you were looking for your files. I'll start
I have
again.
them.
I was saying, having had the benefit of this engagement, and we know that we have those A1 statements, supplementary statements by Mr. Adams in our file 9, which we are still going to look through so that we can zero in on the relevant documents. What do you suggest? What conclusions do you suggest the Commission must draw if a reading of those A1 statements together with the Section 27 referral affidavit do not support the summons in the terms as reflected?
And in the absence of anything else before the date of the issue of the summons.
Just pause there. What else would there have been? Because so far we have understood that the summons arise from the Section 27 read with the dockets in Orlando and Cape Town, the A1s, and read with the supplementary affidavits by Mr. Adams. That's all we have. Is there anything we have missed?
No, I think the point I was trying to make, Council, is we just need to check that there isn't anything else before the 6th of February other than the 27 and the additional statements.
Okay.
What I'm trying to get to, is I don't know whether he attached anything else. Was it just the A1? But that is all I expect would have been there.
On that point, what could potentially be there? What should we be looking out for?
The only thing that could potentially be there is if he, over and beyond the additional A1, attached documents in support of. That could be the only thing, which might then talk to, but that would be the only other thing.
Now we've settled the documents that we should look to try and understand the basis, the legal basis for the Section 28 summons. My question to you was, what would your advice to the commissioners be as regards how they view this Section 28 summons in circumstances where all the documents that you have listed, we have just discussed, do not factually or legally support this Section 28? What would your advice to them be?
Then the investigation is problematic. Whatever follows is problematic.
And what do you say about its legal validity and everything that arises therefrom?
Short of a proper detailed explanation from the investigators, and if an explanation is given and one that is not accepted by the Commission, then that investigation falls away. It has to be a legitimate investigation. It has to be supported by documentation. That is the basis, Chair and Commissioners, on which IDEC has worked on all its other matters. This matter cannot be an exception. And so what I'm saying is, if we find that there is in fact an exception which ought not to be there, then it must be explained by those who did it, but then it goes back to, so what do you do with it now?
Now, that is relevant, I think earlier you indicated, that is relevant to docket number 453, is that, or /06/2025. The docket you said is still under investigation, the docket in which J50 was issued for the arrest of General Kumalo, I think, and General Madondo, but which arrest warrant was then suspended. This is where that investigation, that is the matter that this investigation results in. That is about manipulation of their own security clearances, am I correct?
That is what I understand, yes.
So, where then we are, as you have testified.
Sorry,
Yes.
can I just understand? The manipulation of their own security clearances is the allegation, and I'm just trying to understand your answer, is the allegation that they manipulated their own security status, or which is the one possibility. The other is they're charged and accused of manipulating other people's security vetting, because maybe let me leave it at that. Which of the two? Because they're not the same.
Yes, as I understand, for example, in one matter, without going into the detail of the person's name, the person put in false affidavits about material requirements towards vetting,
Their own vetting.
their own vetting.
Okay.
And then that was accepted as is by persons who ought to have interrogated and or engaged the process and to have picked up during this process that the person had manipulated and or lied. And so the question was, did the second person knowingly overlook that there was an untruth, a manipulation in the process? But it ordinarily starts with a person whose application is defective, for lack of a better word, Commissioner Baloyi.
So what it is with that case is that one of them misrepresented certain information to the other, and the other did whatever they did to approve the vetting, if approve is the correct word. And your question in respect of that second person is whether they did so knowingly or not. Is that what you're saying? Thank you.
Thank you, Commissioner. I need to move to a different document, but before I do so, how many Section 27 affidavits are you aware of that Mr. Adams filed with IDEC?
The one that we referred to earlier?
Are you aware of any other that either preceded or post-dated that one?
I'm aware of the 27 November. 21 November.
Of November.
Correct.
That's the only one.
Yes.
I ask because in the course of our investigations, it would appear that there were actually two Section 27s with some differences between them. I just wanted to establish whether you were aware of both of them.
I'm aware of the one that we've been going through the past few days.
And if I recall, this one that we've been dealing with, you say was solicited by Chief Perumal and then eventually landed on your desk. And that's the only one you have worked with.
Correct.
Okay. I need to then refer you to a different document to understand how the system works. And I'm looking for the Section 28.1 authorization. I have it at page 3288. Apologies, not that one. I'm looking for the 2813, 3307. That, I think we are still in file 8 still.
Do we put away 3?
Not too far, Chair. We'll be coming back to it.
Please look at the one on 3282. Is it that one, or are we looking for a different one?
3282, that's a 2813.
It's also a 2813.
Yes, there are a few of those. And
This was the 6th December. I remember there was a later
Yes.
one that you showed.
The later one, Commissioner, is the 28 one of 30th May,
Which one are we looking at?
for the 6th of December.
Okay.
20.
There are actually, there is 13285. But the 3285 is the designation. What I'm looking for is the actual application. And that's how I landed 3307. Thank you. Are you at file 83307?
Correct, Council?
Now, I understood your testimony on Thursday, in summary, to be Advocate Ramsamy. You handed the Section 27 to Advocate Ramsamy. She considers the affidavit together with legal provisions. She then arrives at certain conclusions and she drafts a Section 2813 application and submits to you for consideration and approval. Am I on the right track there?
That is correct.
So I see at 3307, it's one such, it's addressed to you. And it says Advocate Santos Manilao and Advocate Ramsamy. It's dated the 5th of December 2024. This is in relation to the list of 12, and that is at 3309. And while we are here, Advocate, I've resisted the temptation, but I think I succumb. The person at 3.12, automotive engineer, who's that? Is the automotive name? Do you have any idea?
No, Chair, these were the names that, when I checked with Advocate Ramsamy, she said they were on a paper that were furnished after Mr. Perumal had spoken to Mr. Adams.
Yes.
Yes.
So, at the risk of asking a stupid question, automotive engineer has got an ID number. Is that somebody we can search for at Home
It should be an
Affairs?
entity that could be found.
An entity.
Yes, ma'am.
But it says engineer suggesting a
No,
person.
it's an entity, from how I understand it.
All right. I'm interested in 313 though. It says any and all individuals or entities whose identities are currently unknown, but which may become known during the investigation. You recall we started with Section 27th affidavit, which identified the first three names. We established that Mr. Perumal, through you suggested Mr. Perumal added the rest of the names, having consulted with Mr. Adams. But then it goes, so that's broadening it. But 313 goes even broader, considering the purpose for which you would be issuing a Section 28 investigating. There should be a limit to powers that are granted. 313 could very well discover my name in there and I become subjected to this investigation. Is that proper though? Because it's a limitless power and authorization here.
Council, it's not limitless because it relates to any and all individuals or entities whose identities are currently unknown, but are limited in which may become known during the course of this investigation.
Yes.
Yes.
But it doesn't go further to say that they are implicated in whatever crime is being investigated.
No.
It's just that the names being known and suddenly there's authorization to go investigate them as well.
it doesn't of necessity mean that they are investigated. Any and all individuals or entities whose identities are currently unknown, but which may become known during the course of the investigation. Once those details come through, investigators are able to determine whether those are persons of interest to be investigated or those are persons whose names have come up and are potential witnesses.
So technically, it's left to then the investigators. If they like me, they come across my name, they don't have to investigate. But if they don't like me, then they investigate. Do you understand my challenge? Because I think too much power resides and discretion resides with them. And that somehow has the potential to undermine the system. Doesn't it?
I take your point, but that shouldn't be done.
Okay.
That is not what the purpose of this insertion is. And it was also for practical reasons. You've got the authorization, you're conducting investigations, names come up, and the names can be either or. So if it is persons who would fall into the category of suspects or persons of interest, then you'd have to come back for an amendment. Yes. And so you are able to then deal with the investigation without the to and fro of the. I do take the point.
Okay.
And perhaps it could be couched somewhat differently, but this is what we have used over the time.
But isn't it a necessary control mechanism that what has been justified to you are the specific names? So you were given these names, there must have been justification to you. We had the earlier discussion about you satisfying yourself that there is a basis to include these specific names. And if that is your system, then paragraph 3.13 should not be there because it means people will be included without it being justified to you who gave the authority. You understand the point I'm making?
I
Yes.
understand.
So 3.13 is very much open to abuse if you're not controlling it, if they don't come back to you to justify. And what you are saying to us now is you gave them that latitude to justify just from 3.1 up to 3.12. But then beyond that, you gave them latitude to justify that, and you were satisfied that there is merit in having 3.1 up to 3.12 to be investigated. But then what you go on to do then in 3.13, and you say to us that's how IDEC has always operated, is you then leave it to them to then determine as they go along to investigate without having to justify to you, which defeats the very purpose of justification to you in the first place. So my suggestion would be, if that's how you were operating, then you may as well just have had 3.13. They come and they tell you, we are going to investigate anyone that may be implicated, because that's the effect of 313. It allows anyone that Colonel Pareachi gets their name, if Mr. Adams had said, Mr. Bodlani, that's all that would have happened. He would have gone and investigated him under 3.13 without coming to you as the repository of the authority to authorize investigations into individuals, without coming to you to say, here's my justification for investigating him.
It was not the intention,
Yeah.
but I do take
But
your-
it is the effect.
It in all likelihood is the effect, and I take the point. And just for reassurance, Mr. Botlani is not in 3.13.
Yeah, we don't know who else Mr. Colonel Pareachi included in there, but he may well, and you have no control over that, you have no way of knowing. And I say Colonel Pareachi not to target him specifically, all your investigators. They may well be conducting investigations of individuals that are not authorized by you and that may possibly not be related to a subject matter with that kind of provision.
The point is taken, Chair.
Thank you.
Thank you, Commissioner. we were still with that application. I see if we go to page 3311.
Sorry, Ms. Zille, maybe before you go,
Yes.
then let me ask my question before I forget. You say at 3310 under 4, participation of other disciplines, and you have the asset forfeiture unit. Was the asset forfeiture unit ever involved with this investigation at this point? And what was their involvement?
So, what we ordinarily do is once an investigation is commenced with, we will send or we will invite asset forfeiture in to know that there's a new investigation. But the investigation progresses for quite some time before they're brought back in because it depends on the stage of the investigation. And their purpose is then to determine, as the commissioners know, whether or not the offences as they are deal with the proceeds of crime and whether or not that must be taken forward.
So you, IDEC, as a matter of course, every investigation you alert the AFU
Yes.
that you're conducting that investigation.
Correct.
Even though on the face of it, let's take a Section 27 referral, and even if on the face of it, your Section 27 doesn't raise issues that may implicate any forfeiture issues, you, as a matter of course, just inform them of that.
That is correct, and they will make an assessment at the end. There are many matters where at the end of the assessment, there isn't a recovery to be made, either in terms of the civil and or the criminal recovery. But it is a matter of practice in the entire NPA that we do refer matters to asset forfeiture, be they to determine proceeds of crime or instruments of criminality.
So there would be a letter that in this docket or this file, this CIN file, there would be a letter that is directed to the asset forfeiture unit that we must have, or we must find.
What we ordinarily do when the team has its first meeting, they invite a colleague from the asset forfeiture unit. And as the matters progress within those meetings, there are engagements and it's usually emails that are shared between the colleagues, setting out what they require if they found anything. And because we are part of the NPA, it's not an invite per se, they are drawn into the matter.
So if we were minded to get more detail about what happened in the first meeting, we would expect, on your explanation, that because there's you seem to now say there's nothing in writing, that's fine. I don't quarrel if that's how you were doing things. But if we were to look into that first meeting, we would and we should find that there was a representative of the asset forfeiture unit, and therefore such a person would be able to tell us, in fact, what happened in that meeting.
Correct.
Okay, thank you. Thanks, Mr.
Thank you, Commissioner Baloyi. Then perhaps just to close up that angle, please go to 3308, same file, same document. And I'm looking at paragraphs 1.3 to paragraph 1.7, where the document provides the nature of crimes that are being investigated. On my reading of them, I don't see how, no, let me ask you a question. In which one in particular would SIU find a role?
So we also invite SIU where there are issues of procurement and or contracts.
Okay.
And they do assist us with the investigation to determine legitimacy of those contracts. It may turn out that there shouldn't be a further criminal investigation in that matter, and the SIU is able to deal with that contract, setting it aside and recouping the money for that department. Because that is generally part of that mandate.
So that's what would be what's set out in paragraph 1.7.
That would be correct.
Then my reading of this, and bearing in mind your explanation, this application for an investigation in terms of 2813 is broader than the section 27F as we have it, because my reading of section 27 does not include any allegations of fraud or corruption pertaining to awarding of tenders and contracts. Remember, that's file 2, page 512. The closest I get to is a general statement at paragraph 4, where Mr. Adams says he suspects that Generals Kumalo, Madondo, and Lushaba were manipulating procurement processes. That's as far as he takes it.
That is where you find it.
So, and we land with fraud and corruption pertaining to awarding of tenders and or contracts involving SAPs and or circumventing of procurement processes at 1.7.
And that also goes back, Council, to paragraph 4.
Yeah, I say at paragraph 4 of the section 27 affidavit speaks to manipulation of procurement processes and processes to appoint. The rest of the affidavit concentrates on processes to appoint, but it just that one throwaway line where Mr. Adams says he suspects manipulation of procurement processes and says nothing more beyond that. Remembering that beyond that he speaks of abuse of the funds, the Secret Service funds themselves, but that's not procurement.
No.
So I'm just interested in just reading that one-liner, how we end up with a potential.
Sorry, I just want to read that abuse of funds, because I seem to think they have a correlation that the funds are
And then I say this on the assumption that abuse of the Secret Service Fund effectively means utilizing the funds not for the purpose they were intended for, which suggests an illegality, and that can never be termed procurement.
No. He, when he refers in paragraph 5, he talks to the unlawful use of the unlawful access and use of the secret funds and the purpose for which those funds are accessed, and it doesn't talk to procurement. It talks to they are accessed in order to give to someone.
And at paragraph 5 only says it's his suspicion that the funds, as he says, quote, became taken unlawfully from the secret funds account to be given to the former police minister, Minister Becky Gaye.
That is correct.
Quote. That's not procurement.
No, that's not the procurement.
Okay.
Let me ask a more direct question on the back of that. What award or what tenders and contracts that were awarded did you investigate or your investigation involve arising from this referral? What tenders have you investigated and what contracts?
They are in the file that must be made available by midday today. That is a file that is still under inquiry, but that is where it relates to, Commissioner Baloyi. It's not in the dockets that were handed over.
In that file, we will find tenders or
In that file-
contracts that you investigate or you are investigating as a result of this Section 27 referral.
That is what I understand, yes.
Sorry,
I
what
just
does
want
that,
to
what
go
does
back
it mean?
into my- Sorry.
You started off by saying it will be in that file. Now you say that's what you understand. What does that answer mean?
Because I had to ask what was in each file so that we could make the files available. Part of the file that must be made available is a complaint that was lodged by Mr. Adams. Commissioners would recall he talked of 3 dockets, then he talked of and a Langlaagte docket. From what I understand, that is where the investigations lie in terms of the procurement of contracts, as well as, it is here.
Well, you may not be able to remember offhand, but my interest is in getting a clear answer from you that you arising from the Section 27, you have investigated or you are investigating matters relating to specific tenders, because we are not speaking generally. There are tenders and contracts that you are investigating arising from the Section 27 referral, and we will find that in a file.
As soon as we get the file, I'll be able to confirm that.
You are unable to confirm now. Well, then you're going to make me ask. You're going to make me ask the question that Ms. Silva asked you earlier, which is, well, if we don't find it, what are you saying? We pronounce about it or we comment about it?
If it's not in the file, that I was told is the file dealing with Langlaagte and with contracts and procurement, then the same answer applies. Then there's a challenge with why it's not there.
Thank you.
And perhaps to take advantage and be more direct, 1.7, does it by any chance refer to the 360 million subcontract awarded to Medicare 24? Does it have anything to do with that?
Not at all.
It's a different contract.
Medicare was a separate Section 27 referral all on its own.
Thank you.
And unrelated.
And while we are on this, do you know how far, do we have a Langlaagte related inquiry and investigation into specifically those contracts here?
That is the file we're waiting for.
Oh, there is the inquiry into the Langlaagte complaint.
That is correct.
Noted. If we go to 3311 on the same file, we're still at file 8. I see there it's dated, at the top it should just show dated the 6th of December 2024. It's signed by you as the ID. Is that correct? How does it work? Because if we look at 3307, it's supposed to be directed to you from Advocate Santos Manilal and Advocate D. Ramsamy. How do you get to sign it? I don't see anywhere where either one of them signed. I would have expected for them to sign, to make application as the heading in the tram line suggests, and then you consider and then you approve or not approve or you amend. So all I see is in this document, we are looking at a document addressed to you. And at 3311, it's signed by you, suggesting to a reader that you made this application to yourself. And I don't think that's how it's intended to read. How do I reconcile that with how it's supposed to read?
So how it is supposed to read is under 8, on 3310, Commissioners, under 8, there's 8.1. It is recommended that there was supposed to be a signature, either from Advocate Manilal or Ramsamy, and then for me to be able to agree and sign off the.
Are you saying that's how it's supposed to have read because that is how normally they read?
That's
Or do they all read as reflected here, that it's recommended that an investigation in terms of 2813 be undertaken and then you immediately sign as if you are the one recommending?
No, there should be space for me to comment,
Yes.
their signature, space for me to comment, and then the signature that followed on 3311.
And that's how normally they would be within IDEC.
That is correct.
Why is this one different?
I honestly can't tell you why, but it is different.
You signed it. I think there's more you can say about this, why it is different. I take it that when you read it,
Yes,
you saw that it doesn't have signature for either Advocate Ramsamy or Advocate Manilal. You saw that it doesn't have space or provision for you to make comment. And you saw that it requires you to sign it and date it. So you didn't sign blindly. You applied your mind to
no,
this
I did
document.
apply my mind to the recommendation, the signature notwithstanding.
Yes, but then who's recommending to you?
The lack of signature. not
Lack of
mistaken.
signature.
Yeah.
And
In this,
having, with full application of mind, you thought it appropriate to sign.
Advocate Ramsamy, yes, she brought this application to me on the 5th. We went through the application and I then signed the application.
Do you know what the risk is? And I don't know if you appreciate it. It's that, or maybe I'll put it differently. What would you say to perhaps an unfair claim that you and you alone drafted this document and you drafted it for yourself and you signed it and nobody else took part in that in the creation of that document? Would it be an unfair accusation, and what would your response there to be if you were confronted with such?
It would be an unfair accusation because there is a process that follows. The application is drafted by somebody and it is brought by them. This portion is missing in this matter. I would, when you read it, it does make a recommendation from the author, which is from Manilal and Ramsamy. They make a recommendation. I agree with the recommendation and I have signed it. I accept that, as we always do, there should have been the signature and the space that we always have for comment, and the comment would have had to have been the recommendation as per 8.1 is either it's approved or not approved.
Did you not notice that before you signed it? Did you not notice that the people who are supposedly the authors of this document do not append their signatures or a date because the date is important, it's not just the signature. The same way you do with that 6 December date, the date when they give it to you, whether it's on the 5th or the 4th, is equally important. Did it not strike you as odd that at the end of the document their names do not appear, nor does the date when they gave you this document?
So Chair, so Commissioner Kumalo, I took the date as is, which is on the front of the document, which is the 5th of December 2024, as being the date of the document.
But normally the same way you do, if you look at dated and signed at on 3311 and then your signature afterwards, the two usually go together. Because, for example, if now they distance themselves from this document and they say, well, we did not make the recommendation, how do we establish that they did in the absence of their signature or the date when they appended a signature to the document?
I hear you. But the document does come from them with the date. It just didn't have the signature. But I take your point. It is done. In IDEC, they do put it in as a memorandum request, and it is usually signed. There is space for comment, and then for me to indicate whether approved or not approved, and then the application is also attached.
And why did you not pick it up or raise it at the time? Because the way you are responding now, it looks like you are seeing this for the first time.
No, I'm not sure why I didn't raise it.
I think, Ms. Johnson, unless there's a page missing or pages missing before page 3311, if that's all of it, if what we are looking at now is all of what was presented to you, then the other incomprehensible issue about this letter is that whoever drafted it, whether Mr. Manilal or Ms. Ramsame, would in fact have put you down at 3311 as the signatory of this letter, because that's what it means. You're a signatory of this letter, and on the face of it, until there's an explanation, which is that the page is missing, then what Ms. Silo is proposing to you, it leads only to that conclusion, which is you either drafted this letter yourself, or a letter was presented, and this is my addition, was presented to you, you made your own changes to it, and then you signed it off. It doesn't contain exactly what would have been presented to you. That's what it looks like on the face of it. And I allow for the fact that a page may be missing, and maybe you can pull out a page that shows that these people made the recommendation, and it provided for you to indicate your approval. But as it stands now, on the face of it, it suggests this is your production.
I can confirm it isn't, but I take the point that you're making about how it comes across.
What it looks like.
But it was not my document.
Yes.
I did not compile the document. The document was presented.
And you understand my point about, if it's not a case of a page missing, then it would be strange that Mr. Manilal or Ms. Ramsame would have signed off at the bottom as if you are the writer of this letter.
Correct.
Okay. Thank you.
Thank you, Commissioner. And we know that from your previous testimony that following this authorization that we are dealing with at CJC 3905, page 3307, on that particular day as well, there was a hive of activity. 2 letters written to, I think it's Lieutenant General Mbuso Kumalo, requesting the dockets, a letter to General Sintumole, your authorization of the panel, the designated members to look into this, and the presentation of himself by Mr. Rapesu at the inspectorate to go obtain the dockets. The 6th of December was a busy day.
Yes, ma'am.
Very. Is that like standard busy days for IDEC?
It is standard when they are starting with an investigation and they are looking for, it depends on what they're looking for.
Yes.
And in this instance, because they were looking for the dockets, allegations being that the dockets had been lost, it created its own sense of urgency, is to locate the dockets, nothing else beyond that.
So you consider the investigation urgent?
The tracing of the dockets urgent, yes.
Why?
The dockets, the allegation by Adams is the dockets are already missing. We are given a referral. We need to register an investigation. The investigation is now registered in terms of 2813. And the first exercise out of that, in order to go forward, is to trace the dockets.
I don't understand why. The referral is not referring a complaint of interception. We settled that one.
Yes.
It's referring a complaint about conduct, specific conduct, as articulated in the section 27. My suggestion is the dockets become completely irrelevant. This is a new complaint that must be substantiated on its own terms. And if I'm anywhere close to being correct, I would like to understand what was the urgency about this particular investigation. Just the allegation that dockets are missing and it's enough to set fire to IDEC and everybody runs in all directions.
That's not what happened, Council.
Okay.
We found out on that day that the dockets must be in Gauteng. I know it sounds like a lot of, it happened in a phased approach. The investigators tried to determine where the dockets are. We then write to Major General Kumalo. He gives an indication of where the dockets are. We have to then follow that up. There's still time in that day to follow that up. And when we finally do follow where it is, we have to stand down because they can only then be made available on the Monday. So it wasn't, we have to get it today. It was, where are they? As you get the information, you follow that information. And when the destination of those dockets was determined, and it was determined that they were in a safe and that they were with a specific general, we went back on Monday.
We didn't touch on it, although we dealt with it with Colonel Padiache about the urgency of obtaining these dockets. And perhaps we will turn to that next. And my idea is to make the point that IDEC dealt with this investigation as of the 6th of December as a matter of extreme urgency, and I just want to understand why. But I see it's 11:04, the commissioners need to break for tea.
Let's adjourn and return at 11:35. Let's
Thank you, Chair.
adjourn.
Thank you, Chair. Chair, Commissioners, I wasn't moving off topic, but just slightly off topic. And we've had opportunity to consider the documents filed last night and this morning by Advocate Johnson. And on a consideration of those documents, it has become necessary for the Commission to update their exhibit files because we have what could potentially be documents contradicting the very documents she has filed. And I was moving on to that topic now. A request has been extended that Advocate Johnson have opportunity to confer with her legal team regarding these seemingly contradictory statements before we traverse those issues during testimony. I don't know if Mr. Bodlan would like to add anything.
I may just confirm, Commissioners, that it is so. I had a conversation with Ms. Sillo last night about what was still outstanding from what had been requested of us. And then I made a request to those instructing me that every document that had been sought must be made available immediately. Even I hadn't had an opportunity to look at those documents. During the adjournment, Ms. Sillo confirmed to me that she's going to deal with some of those documents. I conferred with the witness. The witness herself was shocked to learn that there are contradictory documents. We request at least about 15 or 20 minutes of a stand down so that we may consider those documents, confer with her, render advice if and when called upon to do so.
We'll come back when it's indicated to us, then let us adjourn.
Thank you.
purposes requested. Your file 9 has been updated. I do trust so has your index, because mine has been. And it's been updated by the addition of 4 documents under CJC 394. So there'll be 4.1, 4.2, 4.3, and 4.4. The documents provided by the witness pursuant to the request and the various subpoenas are attached as CJC 392 and their subs and CJC 393. So those are the documents provided by the witness. The documents we have just added that required Mr. Bodlani to consult with the witness are then CJC 394. That is just to locate us. Advocate Johnson, you confirm what I just informed the commissioners. I'm not misleading them, am I?
Correct.
Thank you. Let's go then to file 9, the very file we're talking about. And let's deal with 393, CJC 393, which should start at your page 3466. Commissioners, we ran copies of CJC 393 as received, but on a proper consideration thereof, it would appear that they were not filed in order. So I have tried to make some sense of them, and I suggest the pages be moved around. Advocate Johnson will confirm if I'm correct.
Yes.
And in that regard, it's, if I say CJC starts at 3466, it's followed by 3467. It would appear that your current 3468 is what should be 3467. So if we could start by swapping those pages around. Do you agree with me, Advocate Johnson?
Correct.
Thank you. So the current 6.8 should be 6.7. And the current...
But what about the fact that 3467 as is says 1 of 1?
Because it will go with 3469. That, what's currently 3467 and I suggest B8 is the document that we have in our file already. You will recall, Chair, our A1 statement at file 2, page 681. It accords with 3467 and 3469. So that page seems to have been mislaid.
I know for the most part this is illegible, but below the rectangle of the current 3468,
Yes.
there's something that appears to be a page number there. I can't read it.
It might appear as a 3.
As a 3, I thought so.
Yes.
Now, if we take 3468 to come under the current 3466, are those supposed to follow each other consecutively?
They would seem to, because if one has regard to 3466, that's the start of the case docket. And then when I get to the current 3468, which we suggest be amended to 67, that seems to be the CAS checklist. And the date appearing at 3468 in the second block is the 29th of October 2024. So it doesn't tally with the statement of January 2025.
So I changed the 3467 to 3468.
That's what you propose.
Okay.
Then that will read and be followed logically by 3469.
Sorry, Council, may I, through you, Chair, may I just so the 3466, if you look at the top, it's got a A1, then a little one in brackets. Then it follows on 3468, it's got a A1 and a little 2 in brackets. But please look at 3470, there seems to be a A1 with a little 3 in brackets. And then it seems 3471 has an A1 with a little 4 in brackets. And I'm not sure if those are the ones that are supposed to go consecutively.
No, I'm going to come to that.
Thank you.
Because beyond the 4 pages I've dealt with, if you look at what was 3467 that I suggest be 68, that is the preamble to the statement, and it bears cast number 542/06/2025. That at the bottom, it's dated the 6th of January 2025. We have dealt with this preamble together with its statement, and that is our current A1 statement at file 2, page 681. And you are quite correct, Advocate Johnson. It gets messier going forward, but we'll try. For the record, Chair, you will recall that we have the report by General Jacobs, who has, General Jacobs is annexure MK15, page 275. There is a table there that correlates the Orlando and Cape Town dockets, MK15. That's General Mkwanazi's annexure bundle, MK15. And in particular, this is the report by Lieutenant General Jacobs. And at page 275, it sets out a useful table. And that correlates the Cape Town dockets with the Orlando dockets. If one has regard to that table, I would say there are 3 Cape Town dockets, 1650 referred to in block 2 and 3, 1651 referred to in block 1, and 1653 referred to in the final block on the table.
Sorry, Council, you're on page?
And page 275, ma'am.
275,
Yes.
thank you.
So if we accept, if we use that as a guide, and now go into our file 9, the current file, at page 3470, that is the cast number 1650. So page 3470 and 3471 bear the same cast number 1650/10/2024, and it's followed by a handwritten statement. And at 3474 is an entry in the investigation diary. I can't make out whose, but once again, it bears the same cast number 1650. Then you get to page 3475. It's a typed affidavit, but it is followed once again by wrong documents. And on my reading, subject of course to correction, 3475 should be followed by 3478, which means 76 and 77 are in the wrong place. Then if, I think as to correct, so that when we reference the pages. So our current 3478 should be 3476. And the current 76 and 7A should, and 77 should be 77 and 78 respectively. Then that takes us to 3479, which is once again a typed affidavit that seems complete, and the subsequent documents seem to be in their correct order. Are you with me thus far, Advocate Johnson?
I am.
So what you then provided are the dockets of cases opened, the 3 dockets opened in Cape Town. We'll have the cover sheet of that case docket at 3466.
Sorry, Mr.
Yes, ma'am.
Before you go too far, the current 3478, which is also marked A14, you said it belongs where?
It seems to go with the old 347, you said the
3478?
the current 3478, I think goes with, follows up on 3475, and I suggest it be numbered 76. It looks like the end of that affidavit starting at 3475. And yes, Commissioner Baloyi, I agree with you that the current 3478 reads exactly as 3480. Yes. I take it it's the second page of either of both affidavits. So you don't get rid of any one of them. You need both pages to make sense of the affidavits. Yes. And if for a moment let's stay with 3475. As currently filed, the affidavit starting at 3475 doesn't have an ending. That is why I propose to bring 3478 forward to make it an ending to 3475. But if then we go to 3780, that appears to be the ending, much as it's worded in exactly the same terms, seems to be the ending to the affidavit starting at 3479. Well, Commissioner Kumalo nods his aid. He seems to agree with me.
There was a slightly different problem.
Yes.
In the photocopies, one page was copied twice in one of the photocopies.
No,
It won't be in yours, so you
okay.
won't notice.
I won't
that.
understand that. Okay.
Sorry, Council.
Yes,
Madam
ma'am.
Chair, to which page did you direct us now?
No. We're still trying to sort out which page follows which. Then we're going to start. Thank you, Commissioner. So then we start at the beginning of CJC 393, that's at your page 3466. And these are the documents you provided us. Unfortunately, that page, the case docket, it's barely legible, but at least in the top center block, you can make out the case number, and I read it as 1650/10/2024. That is then followed by the reposition 3467, and you will note in the second block, it's got the date of 29/10/2024, signed by Captain, I can't make out the name, but the captain. Then it jumps to 3468, our new 3468, and it's got cast number 542/06/2025. That's a Brooklyn case, and that's what we call the Mukwele case. For your notes, that is the front page of the A1 statement, as we already have it at file 2, page 681, together with the following page at 3469. Then once again, at 3470, it's a Cape Town 1650/10 statement. So that's when the case was opened in Cape Town. At 3471, bearing the same case number, we know the offense there is defeating the ends of justice. And 3472 is Mr. Adams's handwritten statement. I assume that it is in respect of case number 1650. There is nothing that tells me, unless perhaps the content just might do, so we retained it there. And at 3473, you will note, Commissioners, that it was commissioned on the 29th of October 2024 at 1500 hours. And that is then followed by 3474, which is a copy of the investigation diary signed by Captain somebody there, and references the statement taken from Mr. Adams. Now, that we should consider that as the pack for case number 1650. Now, you recall, Advocate Johnson, we're going through this exercise because we established that IDEC received a Section 27 affidavit on the 27th or 21st of November 2024. And the idea, I think we've established that it was fairly deficient for compliance with Section 27 itself. And you indicated that the dockets, the relevant dockets, the A1 statements in there, plus the supplementary statement, would cure whatever legal deficiency there was in the original affidavit. And collectively, that's what informs the Section 28 summons. That's the purpose of this entire exercise. So let's look at 1650, this one that we've been discussing, which would start at page 3466 to 3474. If you go to page 3472, that is Mr. Adams's statement. Another time he opened this case in Cape Town, I'm at 3472, in the second paragraph, it reads, a cover-up of Major General Lushaba's Sunnyside case of robbery, whereby official state firearm, laptop, and cell phone was stolen after acquiring the services of a prostitute on 5 August 2022. Lieutenant General Kumalo instructed Major Likalakala and Brigadier, looks like either Monyani or Monyana, it fell off in the copying, to ensure that there would be no investigation into the conduct of General Lushaba as per Valeria case 38/822. The prostitute was paid for her silence using monies from the Secret Service account. New equipment was bought for Major General Lushaba by again abusing the Secret Service account. Evidence to this effect is available. You see where I'm reading?
Yes.
So this particular case relates to the so-called cover-up of General Lushaba's, I don't know if it's a crime, misconduct, but concerns with how Major General Lushaba ended up losing his equipment. I then look at the statements that you have provided, A1 statements that you have provided. These start from page 3479. There are 3 statements. And none of them speak to this particular issue raised in docket number 1650 in Cape Town.
On
The statements,
3485.
they go 3484. That's how far they go to 3484.
Yes, what I'm saying is that.
Oh, sorry,
Sorry.
3486.
Yes, but
3486.
is council saying that other than that handwritten statement, there isn't another statement referring to the issue of the Lushaba housebreaking?
No, relating to the cover up by General Kumalo, who instructed Major General Galagala and Brigadier Munyani or Munyana to ensure that there is no investigation. The statement we are looking at 3485, on my reading, speaks to the housebreaking. And overleaf at 3486, he says, after making this report, I make inquiries. And Mr. Adams says that he could not get a case number. I was concerned that my report was being swept under the carpet. I don't see in this January 2025 statement any allegation pertaining to the conduct of General Kumalo, General Lekalakala, and General Munyama. Do you?
I see that.
You confirm that. And then staying at 3472, it concludes with the words, evidence to this effect is available. Did IDEC ever obtain that evidence?
I'm unable to respond to that. I don't know that we did get.
So, sorry, I
I'm
missed
unable
that.
to, sorry, I'm unable to respond to that. I'm unaware of what follow-up they would have made.
Now, do you know who within IDEC became the investigator in this particular complaint?
The one with Lushaba,
Yes,
that is Mr. Padiachi,
Mr. Padiachi.
yes.
So if anyone should have called for that evidence, it would be Mr. Padiachi.
Correct.
If you go to 3474, that is the investigation diary of, I think, the officer who took the complaint. I'm looking at line 8, where it describes the modus operandi. It appears that suspect, Lieutenant General Kumalo from Secret Services, neglected protocol and instructed Major General Galagala and Brigadier Munyani to not conduct investigations against General Lushaba. So that is the officer's interpretation of what's contained, the summary of the A1. Okay, then if we move forward then to 3475, we're just following the sequence of the page numbers. What we have here at 3476 now is the statement by Mr. Adams, commissioned by Mr. Perumal. At paragraph 2, you will recognize that that statement is our A1 statement in the docket. At file 2, page 3478, we have, no, it's not this one. My apologies, I take it back. This is a second issue now. The allegations related, I'm reading at paragraph 2, fourth line. The allegations related to the highly questionable appointment of General Khumalo as the head of crime intelligence nationally. The former Minister of Police, Bheki Cele, was also involved in this, while several high-skilled generals within CI were overlooked. At paragraph 3, Khumalo's vetting processes were allegedly fast-tracked by Masemula, who knew that Khumalo did not have a top-secret clearance for many years. And then the last line at paragraph 3, I suspect that the vetting processes were manipulated in favor of Khumalo as well. My interpretation of what's contained in paragraphs 2 and 3 is that former Minister Bheki Cele was involved in the questionable appointment of General Khumalo and overlooking other highly skilled generals. And secondly, at 3, Khumalo's process was allegedly fast-tracked by Masemula, who knew that Khumalo did not have a top clearance certificate. I don't know. I take it fast-tracking in and of itself is not a crime, but what's so to be expressed here is the unlawful conduct by Minister Cele had the support and participation of General Masemula. Do you get to the same conclusion as well?
Yes.
Now, you remember Section 28 that has got a list of people. This is the only statement I found where current generals or high-ranking members of crime intelligence, where their security clearances are questioned. And I see only General Khumalo. I can't find any other basis for General Madondo, Galakala, and that entire list. And I do not have any other A1 statement that introduces them by Mr. Adams being the complainant.
If you look at, through your chair, if we look at 3479, paragraph 2, on or about early October 2024, I received information anonymously surrounding alleged fraud and corruption being perpetrated within the Division Crime Intelligence of the SAPS. The allegations related to the questionable lateral transfer of Major General Madondo from KZN to CI head office by Lieutenant General Khumalo, who was assisted by other senior generals to do so, knowing that she failed a top secret clearance for many years. That is where I see it.
Okay, so that statement then introduced General Madondo.
That statement introduces.
You remember we have Brigadier Van Vuren, we have, I think, Brigadier Bobby, we have Mube, we have all of them. There are about 8 in our Section 28. We account for only 2 if these statements get us there, but just for the moment, accept that they do. We have only 2 whose vetting clearances are questioned. Do you read the documents as I do?
Yes, in these, the vetting that is being questioned is that of General Khumalo and General Madondo.
Yes. So our Section 28 is, in part remains unanswered. We don't know why you are inquiring into the vetting of the remainder of the people listed there, except of course for Brigadier Mukwele, because her statement is different. My second question is, if page 3475 suggests that former Minister of Police Bheki Cele was involved in this, I take this to be the crime. Am I reading it correctly? Julie assisted by General Masemula, who fast-tracked the clearance of General Khumalo, knowing that Khumalo did not have a top secret clearance for many years. My first question, what crime is being complained of here?
I am aware that from a certain rank, they are all supposed to have security clearances as per their own internal requirements. And that not having security clearance at a specific rank does not allow you to occupy that rank.
Yes.
Yes, and so for me, it would be, it is more a contravention of either the Intelligence Services Act and/or the contravention of a standing order of the South African Police Services.
And what crime is that?
So in this paragraph,
If I may just add, remember, we should keep at the back of our minds Section 7, bracket 1, bracket capital A. What crime is that to bring whatever was happening here, assuming it is correct, within the mandate of IDEC?
so we are reading one statement.
Yes.
And the question you asked in council is based just only on this paragraph and what crime it commits.
On the vetting issue.
On the vetting issue.
Yes, on the vetting issue.
So if a vetting is fast-tracked, what crime is committed? So if a national commissioner fast-tracks the vetting of one of his generals, what crime is committed there?
The likelihood, Commissioner Khumalo, is that in the manner in which it is done, that there could be fraud having been committed because there are certain processes that happen, and there's, it can't happen in 3 days. There's checks, there's, you've got to go and do background checks, financial checks. There's quite a few things that must happen. So it would mean that either something fraudulent happened, which could be the only case, but the bypassing of the vetting would be a contravention then in terms of the intelligence services. So other than the fraud, if it took place, there isn't anything else there that would bring it into the mandate.
The question, Ms. Siddler's question is, what places that within the mandate of IDEC? Even if what you're suggesting were to be shown to have happened, they fast-tracked it and they committed some fraud in the process, why would that be something that falls within your mandate in 7(1)A?
Just merely in terms of the fraud, nothing else.
But you do remember that when you appeared last time, you accepted that the fraud, theft, in that list, forgery and uttering, they have to be related.
Yes.
To the main,
To a financial crime or commercial crime.
a serious corruption. So why do you say that would be so in this case? Why would the fast tracking of a security clearance or vetting constitute a serious crime of corruption that falls within 7(1)A?
I hear you, Commissioner, but I can't take it further than the point that you've made.
Is another way to your answer a clearer way that you don't see why it would be a crime
As it stands here, I cannot say.
that comes within your mandate?
Yes.
All right, thank you. Thanks, Ms.
And we know that General Khumalo is facing charges and potential arrest under case 453/06/2025, and that's pertaining to the vetting issue. Is that correct? The warrant of arrest that was suspended, it relates to the vetting issues, doesn't it?
I speak under correction. It relates to the vetting issue of General Madondo.
Of General Madondo?
Yes.
And
And the fraud related to that vetting,
not General Khumalo's own
not General
vetting?
Khumalo's vetting. It relates to a role he played allegedly in
General
that
Madondo.
contravention.
Thanks for that, thank you for that clarification. When you,
So he potentially faces an arrest for something that may not fall within the mandate of IDEC, given this last discussion that you and I had.
I cannot say that not having full sight of all the evidence, given that the allegations against General Madondo in that matter relate pertinently, from my recollection, to her having committed fraud, having misrepresented her position, and that he then knowingly accepted that fraud and then perpetuated the process further, not
That's
the
why.
vetting.
Yeah, that's why I limited my question to our vetting discussion, that insofar as that a charge that he's facing may relate to vetting, one of the charges, if there's more than one, may relate to vetting, that potentially may be a charge which doesn't fall within the mandate of IDEC, given what we have discussed.
Yes, it would only be the fraud relating
Yes.
to the alleged fraudulent documents, remarks, etc., that would have been made by General Madondo.
Thank you.
Johnson, do you not sign off on the processes that lead to the warrant being issued? Does that happen behind your back? I was under the impression all along that before your investigators can seek warrants, they have to come to you for sign off.
No, Commissioner, what they do is before they sit with the prosecutors and they then compile those applications for the warrants. They are checked by the prosecutors and by the deputy in that team,
So you play no part in that process?
not in the warrant process. We are then briefed afterwards that, or before the warrant is executed, sorry, Chair, that before it is executed, we are then briefed that there is an impending arrest.
Thank you, Commissioners. Then on the logic of case number 453/06/25, against General Khumalo regarding General Madondo's vetting, or the lack thereof, I take it IDEC is preparing to charge and arrest former Minister Becky Cele and General Masemula for General Khumalo's own vetting shortcomings. Logic dictates that should follow.
As I indicated, I'm not vested with the cases at the moment, but that logic does.
That
follow.
logic does.
Yes. I can't argue the logic away.
It's on the logic of your answer. Would it be appropriate, though, to be investigating such and threatening to arrest Minister Becky Cele, former Minister Becky Cele, and General Masemula for the fact that General Khumalo was hired into crime intelligence without vetting clearance, in the absence of any fact that he in fact did not have clearance, which was an absolute prerequisite for his appointment? Is it appropriate to follow that line of investigation culminating in potential charges and arrest based on what you have at 3475?
No, unless they fall within other offenses that are not here.
Well, it doesn't have other offenses, that's
Yes,
why. And this is a statement that was commissioned by Mr. Perumal on the 6th of January 2025, as you see from page 3746. And just like our previous
Sorry, page
3476, you remember we changed?
3476, yes.
Yeah. We changed numbers,
Yes.
numbering. Just like the previous one we had, they seem to have this perennial problem of being signed both at Pretoria and Cape Town. It's consistent, that error, through all of them. Are you able to shed some light as to how this comes about?
So, when the Commissioner of Oaths chair fills in, the Commissioner of Oaths fills in, as you see, they sign their full names, their office, the address of where they are stationed, and the agency for which they work. It is for that reason, on the right under Mr. Perumal, you will have the full names, ex officio, he's the chief investigator, the investigating directorate, corruption, IDAC, Brooklyn, Pretoria, National Prosecuting Authority of South Africa, Pretoria. The part immediately under Mr. Adams' under Mr. Adams' signature, that says where they were when they took it, which was, they took it on the 6th day of January 2025, and it was done in Cape Town, with Adams having signed in Cape Town. Mr. Perumal signs as the Commissioner of Oaths, but that address that he appends is the address for where he is stationed as the Commissioner of Oaths.
No, if I may just interject, I apologize. My challenge lies in the wording above Mr. Perumal's signature. You see it reads thus, done and signed to at Pretoria on the 6th day of February, that's typed. And at the conclusion of that paragraph, it says, in my presence at Cape Town.
No, they have to explain. That I hope is just an honest error.
But it happens across all of them.
Yeah, because if we work on the logic of how it's up, everything else is logical, including the date stamp, because IDAC only has a national office, which is Pretoria, but they, Councillor, can't argue that away.
Oh,
Yes.
No, I'm not attributing it to you in any way. I thought perhaps you might be able to shed some light.
No, I absolutely cannot.
If we then go to 3477, it's a preamble to a statement, but this one, if you note the top right corner, it doesn't have a CAS number. And at 3478, it lists fraud and corruption as the offenses. And as you correctly pointed out earlier, the statement, it doesn't have a handwritten statement from the docket by Mr. Adams. Somehow it's not available. What we have instead at 3479 is a statement, once again of the 6th of January, signed by Mr. Adams and commissioned by Mr. Perumal. This is the affidavit you referred to a short while ago regarding the case, the transfer of Major General Madondo.
Correct.
And now this is the case you suggest both General Madondo and General Kumalo were due to be arrested for in June 2026. I understood you correctly.
This would be Brooklyn 543.
Yeah, that's what you had indicated earlier. We know 453 is in respect of the top secret clearances. You recall when we were looking
Yes,
at...
that would be, yes, if you look at, I think, sorry, Chair, I don't mean to waste time.
No, not at all. With the chair's permission, of course.
Because if you look at 3481 and 3482, if the numbers have remained, that's Brooklyn CAS 543 of 6/2025, and that is the CAS that then refers, yes, correct, to Madondo and Kumalo.
Now, staying at 3479 then, we say the allegations relate to the questionable lateral transfer of Major General Madondo from KZN to CI head office by General Kumalo, Lieutenant General Kumalo, who was assisted by other senior generals to do so, knowing that she had failed to secure a top clearance for many years. First leg of that, why is IDEC charging General Madondo for that based on what Mr. Adams alleges? What wrong did she commit by being laterally transferred? There is no suggestion that she committed fraud by misrepresenting or otherwise her clearance position or status.
It is not in this paragraph, but I do understand that that is what is being investigated in 543 of 6, 2025, is fraud committed in getting, she committed fraud
But-
in order to have herself laterally transferred.
How do you land there? This is all you have
Yeah.
regarding her transfer.
Yes.
How do you land at a place where you say she committed fraud?
No, I'm saying it is not in here.
Where is it?
It is in the rest of the docket where they have other statements. They're not Adam's statements. So I take your point again, as we did about the vetting, but just to indicate that there was in fact a fraud investigation that that was undertaken, given her own fraudulent, allegedly fraudulent conduct. It's not in this paragraph. I accept that.
I take it that by the time we apply for an arrest warrant, the charges are finalized. And I know that is the docket we had agreed we will tread carefully around. But on the basis that you have an arrest warrant, that suggests you have an application for a J50, which suggests you have finalized the charges. So those are more or less cast in stone. From your recollection, what is the fraud she said to have committed without undermining whatever ongoing investigations there are? If you can.
I have the answer, but I'm unable to answer it without casting aspersions on General Madondo on a matter that is still pending review.
You are about to arrest her, Advocate Johnson, on the strength of a charge sheet
Yes,
that criminalizes some or other of her conduct.
yes.
I think you may disclose. You can't take that back. The only way you can take it back is for that warrant of arrest to be withdrawn and the charges dropped. So it doesn't, the nature of the fraud that underpins that charge and justifies the J50 remains. Whether you say it here or you don't say it, it's there on record. It can be changed.
I understand that, but if Chair, you will allow me, this matter is under review. I am cautious, having removed myself from the matter, that I shouldn't be saying anything that has the potential to prejudice that outcome. The review relates to representations she may have made, and it goes to an independent panel. And I'm merely saying that any utterances I make might have a negative influence. And I shouldn't do that, because that matter should be adjudicated on the strength of what is there before an independent panel. I'm not sure if the chair would allow me that, but that is the basis on which, Chair. I'm not trying to be obstinate. It is the basis on which I would prefer not to answer.
I'll support you in your request to the chair. I'll leave it there. I will not pursue it any further.
Can you please articulate what you said again, Ms. Silva?
Chair, Advocate Johnson made a heartfelt plea to the commissioners.
Yes, I heard
What
that, but I'm not quite sure I followed what you said.
what I said was, I shall not pursue the matter further.
Oh, thank you.
Yeah. Well, I hear Ms. Silla is not going to pursue the matter further, but I want to ask a different question. You're related to this. Your code of conduct says something about you examining or satisfying yourself about whether evidence was lawfully obtained or material that is potentially going to be used as evidence was obtained lawfully or not. It says that. Now, we know in this affidavit, and your code says that, I think you must be familiar with it. If you want to check, you can look at D2, G, and then I think, rather H in fact. And then if you want, you can look at I, but you're familiar with this. Now, in this affidavit, Mr. Adams says that this information about General Madondo, he knows it from the documents that were pushed under his door in Parliament. And you remember we had this conversation last week about crime intelligence information having clearly been obtained, not lawfully given. Did you, when you see an affidavit that says this, or when you get a briefing, because you must have been given a briefing, I expect you would have asked the question, how do we know this? Where did we get this information about the vetting of General Madondo? And you would have been told, what were you told about it? How this information was obtained?
According to the feedback, the information was obtained, Commissioner Baloy, through the Section 28 subpoena processes that followed after the 6th January engagements with Mr. Adams.
Okay.
So documents were subpoenaed and they would have been provided.
Well, in his affidavit, he tells you, or he tells Mr. Peruma, how he received this information, the very affidavit you're looking at, and he says, I attach here 2 documents which were pushed under my door, my office door at Parliament, and which relate to Madondo's application. Now, it doesn't call her general, so I'm reading, it's not me being disrespectful to General Madondo, which relate to Madondo's application for security clearance marked FA. So Mr. Perumal, or Chief Perumal, knows from this that he's now receiving and looking at information that, that was not lawfully obtained, and that Mr. Adams is not entitled to have access to and to have sight of. And so my question to you is, was that inquiry that your code of conduct says you must satisfy yourself whether that evidence was lawfully obtained, was that done in this case? Or you were all just happy to get the information and then carry on because it takes you down a particular path of inquiry?
No, Commissioner Baloy. I hadn't gone through the details of all his A1s, but I do see here where reference is marked to FA1. I have not seen FA1. In fact, when we were conferring, I was saying, am I missing something? Where's the FA1 that ought to have been here? If in fact FA1 was provided to Mr. Perumal, then we have to determine what that FA1 was. And if it is a classified document, then that is a problem. That should be dealt with. I didn't see, I haven't seen FA1 at all.
Yeah, let's assume that FA1 is exactly what Mr. Adams says it is. He says it relates information or a document that relates to Madondo's application for security clearance. Let's assume that for purposes, because that's what he tells us. Let's assume it's that and it was attached. You say it's a problem, it should be dealt with. What is a problem about it? What is the problem that you say it is a problem, and when you say it should be dealt with, what does it mean?
So, if the document is in fact a classified document, there are two things. One, Mr. Adams should not have been in possession of the classified document. If it isn't a classified document, we all agree that that isn't a challenge. If it is
Even if is it not a challenge though, even if it's not a classified document, it's crime intelligence information. He didn't get it lawfully. It contains the personal information of a person, and he's telling your investigator, your chief investigator, that this was not given to me by General Madondo.
it was under my door.
It was put under my door, so we know he didn't get it properly. Yes, so it seems to me it really doesn't matter. It may have different consequences in terms of the extremity of the consequences of it, but it remains a problem, even if it's not classified, no?
Correct.
Yes,
And so steps should be taken
yes.
for the handling of a document.
And those steps would be, those steps would be against Mr. Adams
The
for
step-
being in possession
Of-
of crime intelligence documents that are not,
classified or unclassified.
that are not in the public domain.
That
Yes.
is correct.
Okay, thank you.
I want to
Thank you.
ask you, Advocate Silo. Advocate Johnson, this affidavits, how does IDEC ensure that the affidavits are independent of IDEC's investigators? It bothers me that it is IDEC that goes to the complainant, purportedly to obtain a statement. And then the same IDEC investigator commissions that statement. How does IDEC ensure that that is in fact the witness's statement and it is not the work of the investigator? In other words, the investigator does not draft a statement for a complainant because we know the starting point is your 27 is deficient. It does not have enough information to enable IDEC to commence an investigation. Or it doesn't even bring what you are saying within IDEC's jurisdiction. Now, IDEC says this is not enough, I want something more. And the very investigator that goes back to the complainant now commissions the same affidavit. How does IDEC ensure that the investigator does not push that agenda to ensure that the follow-up affidavits now contain the information that will clothe IDEC with jurisdiction it did not have when the complaint first came in? I mean, is it not more appropriate to say, your statement is not enough, go make a statement that deals with these issues, have it commissioned, and then give it to IDEC, instead of IDEC being the one that solicits the affidavit and commissions the very affidavit it has solicited?
So, if I can start one step back, ordinarily, Commissioner Kumalo and I know that this is within your remit and knowledge. When investigators, and it's not just IDEC, whether it is the detectives, including DPCI, they go and take statements of the witness, and they commission the statement. The check and balance that we have sought within all of the law enforcement fields over the years is to ensure that it's not one investigator going down to take a statement. In this instance, it was the prosecutor, Advocate Ramsamy, who was supposed to have been present, together with Mr. Mansa and Mr. Perama. So much so that it must be an engagement with the witness, and as the witness talks to the issues, they are noted. And then the statement is drafted. It has to be read back to the witness. And when the witness agrees, the statement is signed and commissioned.
That's what happened in this case.
In this case, that is why there were the three of them. And that is the practice. I'm unfortunately not
Is
in.
it to avoid the very issue that I'm raising, that it cannot be
One
the
person-
same investigator going to a witness and saying, do a statement for me and I will commission it for you.
Correct.
Especially in circumstances where even the original Section 27 was solicited by the same investigator. It's different from a police case where a complainant would come to a police station and would lay a complaint or make a statement. Then the investigating officer would do follow-ups. Here, the original statement is solicited by the same person who commissions the follow-up statements.
I hear you, Commissioner. I can't take it further than the point I made about why there's more than one person who goes.
Yeah.
But I think in terms of perhaps advice and recommendation, it should be stipulated that it is preferable that that kind of engagement not happen and it be an independent investigator.
And I'm not suggesting that this is what happened here.
I
But
understand.
you can see the danger of an investigator who doesn't like a Sandile Kumalo finding a complainant and say, you know, we're going after Kumalo, so make a statement along the lines of Section 27. I will commission it for you. And on the basis of the very statement, I will then commence an investigation against, you know,
I
the
take-
person that I don't like.
I take Commissioner's point.
Thank you, Commissioners.
Just
Yes, Commissioner.
just to clarify names, you have more than once referred to Mr. Manta. Is that the
Yes,
same person as Mr. Rapesu?
Rapesu.
It's the same person. Thank you.
Oh, sorry, thank you, Commissioner. I thought it was yet another person. I had him down as Mr. Manta. Oh, okay, clarified. Staying with 34779.
Sorry, 3-4?
Staying with page 3479. This is regarding General Madondo. And following on your engagement with Commissioner Baloyi, I'm at paragraph 3. We know the complaint is that she got this lateral transfer without a top secret clearance certificate. At paragraph 3 states, Madondo poses a risk to CI, the subs and the country. I'll skip the next sentence. The last one, I don't understand how a senior officer who cannot be trusted is able to access and be in possession of intelligence reports and documents. Now, on the basis of these allegations and subsequent investigations, then IDEC has charged General Madondo in terms of CAS 453/06/25, correct?
Correct.
Why, I take it Mr. Adams is also being charged. What's good for the goose must be good for the gander. If General Madondo not having that clearance certificate poses a risk to CI, the subs and the country, I dare say so too is Mr. Adams. You agree that he doesn't have it, you're not aware of him having a top secret clearance certificate, and yet he is handling documents seemingly that come from crime intelligence and for which he doesn't have lawful access or authorized access. Once again, we are in that logical terrain where I say, if we accept that General Madondo has committed a crime and poses the risk that is articulated in paragraph 3, so equally too must Mr. Adams. Logic would dictate for me unless I'm persuaded otherwise.
No, logic dictates correctly.
Yeah, correct. So we can expect other IDEC to act at least on their very whistleblower on this part, on this point.
If I speak under correction.
Absolutely.
But he is arrested, I think, amongst others, for this contravention.
By IDEC?
Not by IDEC.
No, it's IDEC. Remember,
Yes.
it's IDEC who sought to arrest General Madondo.
Yes.
And this is part of the same investigations, facts flowing from the same investigation. So arresting General Madondo, equally I say, unless there's a reason why IDEC then decides not to take action against Mr. Adams, would there be a legitimate explanation for that?
No.
No. Well, we will see. Lastly, when we started last week, we've been asking about the documents that Mr. Adams says, he does say so in his section 27, that were shoved under his door at Parliament. Now, he says here, specifically those which relate to Madondo's application for security clearance marked FA1. That tells me that IDEC has those documents. They are within IDEC.
And that is where we need to look at, is the document that we said would come just before lunch, the other file. And I did send you that file, Advocate Maga.
Oh, we'll check that, but at least for the moment, we know that IDEC has them.
It should be in that file, yes?
No, you are answering the way. I'm saying for a fact, IDEC has FA1. The documents that were part of the documents shoved under Mr. Adams' door.
I cannot answer till I see the file, because
No.
I didn't see FA1.
The affidavit is telling you. The affidavit itself says they are attached marked FA1.
Yes, if he's given them as FA1, then they must be there.
FA1 is not,
I did not
at
see
least
them.
FA1 is not in the file that I got. The sheaf of papers you gave me doesn't have FA1. But I argue to you that on the basis of what he says at 2, Mr. Adams, I have no reason to doubt that Mr. Adams gave the investigators those documents which he marked FA1 to this particular statement. So IDEC has them. It can be a quibble, otherwise
No.
you are forced to then say Mr. Adams is misleading in that affidavit at paragraph 2, and you've got no basis as far as I'm aware to say so.
Correct.
So I know this affidavit was commissioned by Mr. Perumal on the 6th of January 2025. You said to Commissioner Balo you haven't seen FA1. To your knowledge, is Mr. Perumal available to assist us if we're to make an immediate inquiry regarding FA1, this annexure? And would he be able to, even if on an emergency basis, just to present himself before the commission tomorrow morning to speak to these matters?
He is unable to.
Why not?
I'm not sure if council did speak.
If I may assist.
Yes.
When we sought some of the documents that the evidence leaders wanted, I think the docket concerning Langlachte, we received an instruction to the effect that the person in possession of that docket is Mr. Peruma. And we sought instructions as to whether we can have a conversation with him. We were informed that he's not well. He was hospitalized during the course of the past weekend, so that we also didn't have access to him. The information I received last night was to the effect that he was discharged during the course of yesterday, and that attempts would be made to get that docket from his office, but we haven't had access to him at all. Fortunately for me, I haven't a medical certificate of any kind. So I don't know what is the actual problem with him. Hopefully during the course of lunch, one will get an idea, because part of the promise that was given to us was that that docket would probably be available around about lunchtime, because somebody was going to be dispatched to his office during the morning session today to try and locate it. So we'll get some information during the course of lunch, and hopefully we'll have something to say to you after the lunch adjournment.
Thank you, Mr. Bodlani.
Thank you, Chair. Thank you, Mr. Bodlani. Then if I may, as has become standard request, that as you communicate with Mr. Perumal, I don't know how, this is one of the documents that we are looking for. We're looking for the FA1 to the affidavit that he commissioned on the 6th of January.
Commissioner, through you, I will take a chance at lunchtime, because it is important to do so, and see if we can get him on the telephone. If not, if there's a family member that does answer and is able to answer their question, is just to ask if he can just give us an indication. That much I will try. But for the docket, I am aware that someone would bring it to us not later than lunch.
Thank you.
Thank you, Chair. Thank you so much, Advocate Johnson. I'm indebted. The next statement we have is at 3483. And once again, you'll see at 3484, it's commissioned on the 6th of January 25. It's got that Pretoria Cape Town problem as well, and by Mr. Perumal. This is the one that I say, we've seen this statement before. It's the Mokwele A1. And I think we have dealt with it sufficiently extensively. My last statement that we've provided to the Commission is at 3485. And this one, you referred us to it earlier. This is regarding the break-in and at General Lushaba's house. But this particular statement I see is commissioned by Mansa Robert Rapesu in Cape Town on the 6th of January 2025, as you see from page 3486. This one, at least as to where it was commissioned, is not as schizophrenic. It says Cape Town.
Yeah, so they didn't move Pretoria to Cape Town for this one.
For this one, yes. But it's still on the 6th of January.
Yes, correct.
Now, from CJC 394, those are the documents that the Commission added. Those are the ones we received. And there are 4 of them. If you flip through them, they're all commissioned by Mr. Mancha Rapesu on the 6th of January 2025 in Cape Town. The testimony that we will hear, and you indicated this earlier, that the 2 investigators and prosecutor, is it Advocate Ramsamy?
Correct, ma'am.
Advocate Ramsamy, Investigator Rapesu, Investigator Perumal went to Cape Town on the 6th of January. Went to Cape Town. And on the 6th of January, obtained statements from Mr. Adams. I think 5 in total. And that all those statements were commissioned by Mr. Rapesu in the presence of the other 2 being Investigator Perumal himself and Advocate Ramsamy.
Correct.
And that what we have at CJC 394 are the actual statements taken on the day. And that the statements we have spent the last time working through, commissioned by Mr. Perumal, are a post-fact fabrication. Both witnesses disavow the validity of all these statements, that on the 6th of January, Mr. Perumal did not commission any statement. That's the evidence that we shall hear.
Okay.
And that they were all commissioned by Mr. Rapesu. To that end, because we are armed now with 2 sets of statements, much like Cape Town Orlando situation dockets, but that don't speak to each other. The witnesses say they do not know the statements purported to be commissioned by Mr. Perumal.
Okay.
They attest to the documents that the commission has submitted this morning at CJC 394. It was a bit of a mental exercise to try and marry them, and both have provided short voice notes to explain why it is they challenge the validity of these documents commissioned by Mr. Perumal. And Chair, Commissioners, through you, I beg leave to play. They are very short notes.
Before you do that, does that include 3485? Because 3485 was
It is by Mr. Rapesu.
commissioned by Rapesu, so should it not be part of CJC 394 if what you are referring to applies to statements in CJC 393?
It would be, except that 3485 was provided by the witness.
But
I
you're not suggesting that 3485 is also a post facto?
No.
Yeah, okay.
It's only those commissioned by Mr. Perumal.
The Pretoria, Cape Town.
The Pretoria, the schizophrenic ones here. Yes.
Then we are clear.
So before I play these clips, because I think they explain and the basis for why they so contend, I must place on record that both witnesses will be appearing before the commission this week. They'll testify to what they state in those voice notes, and their statements should be coming through any moment soon. So it is necessary that through them, I explain the challenges to Advocate Johnson, and then after lunch, we can then compare the two sets of statements to determine why their advice is important for our purposes. Very short statements. Thank you, Chair. We play the first one will be a female voice, the other will be a male voice. When you hear a female voice, that's the voice of Advocate Ramsamy. When it's a male voice, that's the voice of Investigator Rapesu. Thank you.
A1 taken by Dylan on the 6th of January, 2026, and then a supplementary taken on the same day by Rapesu, 6th of January 2025. So why would two investigating officers sitting in the same boardroom have taken two different statements on the same day? And I can confirm that in my presence, there was only 4 statements taken. They were the 4 supplementary affidavits, which I have provided to you. The A1 was not taken in my presence, and it could not have been taken on the 6th of January. One, we didn't have the Cape or the Pretoria stamp with us, as is clear from the supplementary statement. 2, Dylan did not take or commission any statements in my presence. 3, we had one vehicle, we all traveled together, and all meals were done together. We even sat at the pool for a long time and chatted and whatever. So when exactly would Perumal have taken the statements on the 6th if we were together?
Thank you. That was the voice of Advocate Ramsamy. And we play the second clip. That should be Investigator Rapesu.
This A1, actually I don't know how to put it, but it could not have been possible because on that day we only obtained the supplementaries. So there was no way Dylan could have obtained that affidavit on that day. And maybe my thinking is that maybe it was signed on a different date, which I don't know. Also remember, I was questioning that signature of Fadil. It looks like someone was trying to jigger it, but I'm not an expert, I don't know, but it looks like. So I think that affidavit is obtained after, it was not on the 6th. So, yeah.
I think both were fairly audible. There's no need to replay, and I think the import of the respective message is duly delivered. So, as I indicated, Advocate Johnson, these are the 2 witnesses who support an exhibit CJC 394, which are the statements that the Commission has added to the exhibit file. And they deny any knowledge of those statements as commissioned by Mr. Perumal, and their testimony will be that whenever it is Mr. Perumal took those statements from Mr. Adams and commissioned them, it definitely is not on the 6th of January 2025 because they were together at all times. And Mr. Perumal himself was present when Mr. Rapesu commissioned the statements.
And he said the signatures were jiggered, means they were tampered with, or they're not a true reflection of Mr. Adams' signature in terms of the statements allegedly taken and commissioned by Mr. Perumal.
Yes.
Did I get that right?
Yes.
Okay.
And he does say, though, he's not a handwriting expert. Let's give him that much.
It's just jiggered, but he doesn't know more.
He says it looks jiggered to him. Now, you must recall that when we were dealing with our A1 statement in the Mukwele matter, our A1 statement in that docket is the quote-unquote Perumal statement. So, Chair,
You say check, let's break. Can I just check something? Ms. Johnson, considering the dates, in the Perumal, I'm going to call it the Chief Perumal statements, which is the 6th of January. And then on the same day, Rapesu also, it's the 6th of January. Would it be normal, I can't think of the correct word, but that you would have an A1 statement on the 6th of January, taken by a member of this 3-member team, and on the same day you have the same team, you have a supplementary statement. It seems to me intuitively that you just have one A1 statement if they were all traveling together and they were interviewing the complainant together. Am I right, that
Correct.
you would have one comprehensive statement?
Procedurally, it does not make sense.
Yes.
What might have made sense is there were 4 statements to be taken. If perhaps Mr. Perumal took 2 and Rapesu took 2,
Yeah.
but on those same matters, and then they end up with a total of 4,
Yeah.
that is logical. But you cannot have one team together, same day, same place.
Taking a main statement and a supplementary statement.
And bearing in mind, Chair, that the purpose was for a supplementary statement to bolster the dockets that were purported to be somewhat lacking.
Thank you.
I think it highlights the danger I mentioned 15 minutes ago,
Absolutely.
where only one person is engaging or not engaging with a witness. But advocacy law, something even more important. In the docket and in the various documents that were given to the court, what was disclosed? Is what was disclosed what we now know as the doctored A1, or is it the correct supplementary?
so far we have the Mukwele docket that we have worked through. It is what the commissioner calls the doctored A1. That's the A1 in the Mukwele docket.
I mean, that is serious misconduct. It's serious misconduct.
It is indeed.
Because it means that is what is disclosed to the court and to the accused.
Indeed.
Let's adjourn at this point and resume at 14:40.
Thank you, Chair.
to the minister's letter, the letter from the minister's office. What is the update on that request?
I must say, I don't know if Mr. Bodlana will be in a position to comment, I confirm that that is the case, and I think it flowed from questions by Commissioner Baloyi and yourself. I must state that in our communication to Advocate Johnson and listing the documents agreed to be provided, somehow that one fell through the cracks, so we didn't bring it to our attention in our communication. Perhaps I should address myself to both Advocate Johnson and Mr. Bodlani. I don't know if they recall. When we were considering an annexure from General Mkwanazi's annexures, we refer to it as MK16. The letter written by the Minister's Office purporting to be a quote-unquote Section 27 referral. You recall that that was followed by an engagement on whether you had responded, you, Advocate Johnson, had responded to that letter, and in what the terms of the response were, and whether that document could be availed. You had undertaken to check in your computer and provide us with a copy. When we wrote the letter to you on Thursday last week, reminding you of the documents to be provided, that particular document was inadvertently excluded by us. Apologies for it. I don't know if you're in a position to shed light on where your search landed you. I would like to believe you remember to conduct the search, it's just that we forgot to include the document in our list. Thanks.
Thank you, Chair. We did conduct a search. I just want to preface it by saying sometimes I type the letter and send it to the PA, or I type it, print it, sign it, give it to her. From my recollection, I would have typed the response. So I sit in the unfortunate position that my laptop, on which that would have been, was stolen at an airport in Windhoek in January of 2025. Commissioners, I lost everything. I had stuff from 2007, everything. And because it was typed and it would have been on the laptop itself, it could not be retrieved. So we did that exercise on the cloud, thinking that perhaps through a backup, it might have gone there. It is not there either. And my apologies, it is an unfortunate situation. It would have helped if I was able to shed light. And then through you, Chair, I did also undertake at lunch to try to speak to Mr. Perumal to find out about his ability and or when to come back. He indicated that he will engage with his medical practitioner and then he will give proper feedback. I did indicate they would have to give a detailed feedback about why he may or may not be able to attend and when he would be able to attend. I will follow up with him again tomorrow morning, giving him some time to do that. And then lastly, with regards to FA1, I then understand, whilst we will all have to go through it still, in the new documents, Council, that you have attached for us, the 3497, which is the statement of Mr. Adams, attaches FA1. And when I just glanced at it, I'm sure we'll all have a detailed look. When you look from 3499, Commissioners, up until 3512, just from a reading of these documents, they purport to be crime intelligence documents. They purport to be internal documents. And I make the assumption, and colleagues will correct me once you've gone through it, but Chief Perumal said that that FA1 would have been in the Langlaagte. I do hope that assists.
So if I understand correctly, you're suggesting that from page 3499, that is the FA1. Subject, of course, to confirmation.
Subject to confirmation. Okay. They all talk to the same subject matter, Council.
Yes.
So I think he may have called them FA1, and that's the bundle that he would have referred to. But of course, you're all going to still apply your minds.
Well, we'll see, because just casting my eye on this particular docket from 3499, that speaks to procurement of forklifts.
Correct.
But you recall the FA1 we wanted was in relation to General Madondo's vetting. So there seems to be a different FA1. Each statement will have, naturally, its own annexure. So that request stands.
Noted.
You note. Thank you. Before we broke for lunch, we had dealt with the dockets and the A1 statements as provided by yourself being IDEC in this case. And then I suggested that as the commission, we have received other statements also commissioned on the 6th of January, but commissioned by investigator Rapesu. And then we listened to the 2 recordings where both would-be witnesses to this commission would testify that they have no knowledge of the A1 statements as commissioned by Chief Perumal. I understand that there are 4 statements in all. I think, commissioners, we need to note that the statement is 3485. These are the documents provided by IDEC. It's the one statement commissioned by investigator Rapesu. On my reading of the statements that we have received from, as a commission, that statement is a mirror, part mirror of the statement at 3491, except for the ending. The one at 3487, this concerns the issue of the theft of equipment from Major General Lushaba. At 3485, that one ends at 3486 with 2 other paragraphs. It's commissioned by Inspector Rapesu. And if you look at 3491, it's the same statement, but it's ending at 3492 is different in that it doesn't have those 2 paragraphs. But the content of the first page in each case is the same. I take it that is a matter that Investigator Rapesu would shed better light on. But as I understand it, it's 4 statements, actually. So then, I tried to, Advocate Johnson, you followed my attempt at reconciling these statements by Investigator Rapesu himself. There are 5 copies in the file, but as I understand it, there are 24 that were taken that day. There is this one that you have provided that mirrors another one to some extent, but not wholly. But that's a matter for Investigator Rapesu to clarify.
Correct.
Then let's turn to the documents that the commission provided. And that will be your CJC 394, starting at page 3487. And if you can keep your finger at 393 from page 3466, because that's the pack with what I'll call Chief Perumal's statements. The statement at 3487, CJC 393 starts at page 3466, and the actual statements commissioned by Mr. Perumal start at 3479. Now, the statement at 3479, which is the first in the PERC, commissioned by Chief Perumal, on my reading, appears to mirror
There's 5 as well. 3475.
Please say that again.
3475.
3475.
You
Yes.
referred us to 79.
That's
The-
correct.
The first one is the one.
3475. If we take, let's start with the first. You're quite correct, thanks, Commissioner. 3475. And I would like to invite you to accept that Investigator Rapesu and Advocate Ramsamy are correct. For the moment, let's accept that. And I'm not necessarily saying they are, but for purposes of our engagement, that the actual statements which Mr. Adams, supplementary statements that Mr. Adams deposed to on the 6th of January are what is contained as Annexure 394, CJC 394. Now, the first of those, of Mr. Perumal's, speaks to, if we look at paragraph 2, the issue of the questionable appointment of General Khumalo as the head of intelligence. That's at 3475. It doesn't appear that when the three of them took statements from Mr. Adams, that they had such a complaint. The closest I get to is the statement at 3489. I'm comparing Mr. Perumal's statements with Investigator Rapesu's statements. But Investigator Rapesu's statement at paragraph 3 just simply says high-ranking police officials, security clearances, and promotions were awarded as a result of alleged corrupt practices. It then suggests that it's got annexures FA1 to FA3, but we don't have those. But the point I seek to make is if the document at 3489 is to be accepted, then there was no reference, at least at the time, in the body of the statement to General Khumalo, and does not contain any allegation of wrongdoing by the Minister of Police, Mr. Beki Cele, being involved in this questionable appointment, as suggested in paragraph 2 of Mr. Perumal's statement.
That is correct.
I also make this point. Remember, in your second day here, I had asked who made a complaint of fraud and corruption. So if you look at the Perumal Commission statement, paragraph 2 specifically mentions fraud and corruption. But if you go to 3489, it simply says alleged crimes, and it does not mention fraud and corruption.
Correct.
So, and perhaps if we go forward, we'd have to jump to 3479. That is now the second statement, but this time concerning General Madondo. And when I look at CJC 394, Investigator Rapesu does not seem to have obtained any clearance, any statement regarding General Madondo. It's still the general statement of 3489. That just speaks of high-ranking police officials' clearance, security clearances and promotions awarded as a result of alleged corrupt practices. But the statement by Mr. Perumal specifically now mentions General Madondo. And just to remind you, we know in our section 27, such detail is not to be found in section 27 affidavit. So it could only have come from supplementary statement. But then I suggested that let's depart from the premise that the supplementary statement is the one commissioned by investigator Rapesu. Begs the question then, assuming we are right, of course, where and how does General Madondo's name come into play, if not introduced by Mr. Perumal? And if so, on what basis? Would you have any sense of how that came to be?
No, none at all, Chair.
Then, if we move on then to the next statement, that will be at 3483, and that is the statement that we have worked with for the past couple of days, and this relates to the appointment of Brigadier Mukwele. And if you look at 3484, it's the one commissioned by Mr. Perumal, and it's the exact same A1 in our docket. If we go to Annex Chassis JC 394, Investigator Rapesu. Commissioner? Or the entire 394. There doesn't seem to be a statement commissioned by Investigator Rapesu relating to the appointment of Brigadier Mukwele. So it would appear that all that was there as of January 6th regarding the appointment of Brigadier Mukwele is what's contained in the section 27 itself. And once again, on the face of it, it would appear that Mr. Perumal then went and solicited this extra statement in the absence of Investigator Rapesu and Advocate Ramsamy. And of course, you can answer to these things. You were not present when they were sourced.
Correct.
But we are headed to, of course, your responsibility as the head, and I'm going to invite your comment, and hopefully have a discussion about the legality of what appears to be happening here. The last statement commissioned by Chief Perumal is at 3485. It's not by Chief Perumal. 3485, it's that duplicate statement commissioned by Investigator Rapesu, but this is concerning the General Lushaba matter. What we have, according to the versions of Investigator Rapesu and Advocate Ramsamy, is a new allegation that does not appear in the section 20, it's not foreshadowed at all in the section 27 as we have it. And the first one you find at page 3487. It's signed by Mr. Adams, commissioned by Mr. Rapesu. And in paragraph 2, he states that on or about early October 24, he received information anonymously surrounding alleged crimes emanating from the Division Crime Intelligence of the South African Police Service. At 3, he points out amongst the information, it was alleged that a forklift was procured by the Division Crime Intelligence without proper procurement processes being followed. Documentation in this regard is attached here too as Annexure FA1. You see that?
Yes.
And earlier, just after lunch, you pointed out that that Annexure FA1 is the Langlaagte docket,
It's in the Langlaagte
which
docket.
is now in the file but as CJC 359.
Correct.
My concern is is Section 27 affidavit, as we have it, is absolutely silent on any purchases of a forklift. Where would that detail have come from in the supplementary, when the purpose of the supplementary was to address shortcomings in the original Section 27?
I venture a guess
Yes, ma'am.
that it, in all likelihood, related to the procurement of goods as was alluded to under paragraph 2 of the Section 27. But that is the only place where you find an item dealing with procurement. And this talks about without procurement processes. So I'm not sure if that is what it relates to. I'm just saying that is the only paragraph in the Section 27, Chair, where I saw something of procurement.
Yes.
So that is where it might arise from, but beyond that, I can't take it any further than that.
Even just casting our eye on the docket, if you go to 3496, that docket was opened in Langlaagte on the 7th of November 2024. And Mr. Adams' Section 27 affidavit is dated the 21st of November 2024.
Correct.
So he was fully aware of the detail as contained in this Langlaagte docket, but omits to provide even slightest reference thereto or detail arising therefrom in his Section 27.
He does refer to the docket in his Section 27. He refers to Langlaagte,
Yes.
from what I recall. And sorry, Commissioners, I'm merely speculating that perhaps it is in that vein that he didn't expand because the expansion would have been found in the Langlaagte docket.
And if we go to the referral, that's file 2. Yes.
Maybe before you leave this page, and this recurs in other pages in these dockets, why would it be written Silverton if it's a Langlaagte police station case with a case number?
When the docket must have come from Cape Town, they would have had to give it a different case number because the docket is now in Gauteng. And what they do is they have cross-references. It would be a Silverton matter to be investigated in Gauteng, but it would still have as a cross-reference the Langlaagte. That's the only explanation I have. I do know that they do that. It's not an IDEC thing. It's the police tend to have those cross-references. So if you're investigating matters in one province, Commissioner Baloy, and they have to come over, you cast them, but you must keep the original cross-reference. So when these matters are resolved, one is able to properly account for them on the CAS system to say Langlaagte stroke Silverton, this is how it was resolved, and they get closed off. Or else you'll sit with an open Langlaagte and perhaps a closed Silverton when they were one and the same.
Okay. So this Silverton here, it's a Silverton in Cape Town, in Cape Town. It's not in Pretoria.
The Silverton that's in Pretoria.
It's not Pretoria.
It's Pretoria.
So why would it be there? I mean, you do have something that looks like Langlaagte at the bottom. It is this Silverton that is confusing me. If at the bottom you've got Langlaagte, then we do have the name of the station. My question is, why would you have a representation that this has anything to do with Silverton? If he did go to Langlaagte to reopen or to transfer, whatever language you choose, a case that he first opened in Cape Town, there's no, Silverton shouldn't be there. Because this has nothing to do with Silverton.
And that is why I indicate, Commissioner, but that's how I understand the system works.
No,
But
I
I'd rather get a
understand.
better explanation for you.
Yeah, I understand. Sorry, let me interrupt you. I do understand your explanation of how it works if a case is being moved from Cape Town. I was just asking about that Silverton. I accept you might not be able to explain it, but the way your explanation of the system doesn't explain this Silverton indication in this docket, and maybe it's for
an investigator to.
for the investigator and Mr. Adams to explain why. All right.
That
Thank
is
you.
preferable.
Thank you.
I don't know if you have your MK16 close by. You'll recall that when Mr. Nkabinde from the Minister's office addressed a letter to your office, he referenced 4 cases, 3 Orlando cases and Langlaagte. And we know that the 3 Orlando cases mirror the Cape Town cases. So Langlaagte is the standalone.
I see that.
You see that. So it can't be that this Langlaagte docket has anything to do with the open dockets in Cape Town. And it's quite correct what the point Commissioner Baloyi says, that then it must have been opened in Silverton, because it bears reference to Silverton on the face of the documents.
The only point of reference I have, Chair, is the section 27, where he does talk of the Langlaagte. He says, I opened 3 cases in Orlando and the Langlaagte matter.
He will help you. It's file 2, page 512.
Advocate Silo, are we talking about 3495?
Yes.
But I see that 87/11/2024 in the minister's letter as the first case there.
And that's the point I make, that in the minister's letter, there are 4 dockets.
Yes.
1 Langlaagte and 3 Orlando.
Yeah.
If we recall the table that's about to be flighted, the duplicates are Orlando and Cape Town. So Langlaagte has always been like a standalone docket. That's the point I sought to make.
It's just, it is referenced, Commissioners, in paragraph 8 of the section 27
Yes.
by Adams, that he does also refer to, I opened 3 cases based on I came to Gauteng, went to Orlando, I opened 3 cases based on the 3 cases I opened in Cape Town, and I also opened a separate case at Langlaagte police station. But that's the only reference I also
Yes.
have, as well as the minister's letter.
But that Langlaagte case, and its detail, is not part of the section 27. The paragraph 8 is just informing you what he did.
No.
Because we know the Langlaagte case is about the acquisition of a forklift.
Correct.
Now, while we're there, before we go to the next issue, just casting my eye on this docket, it's got its own statement at 3497. It's also dated the 6th of January, 25, and commissioned by Mr. Rapesu at 3497. And at paragraph 3, he states, amongst the information, it was alleged that a forklift was procured by Division Crime Intelligence without proper procurement processes being followed. Then he says documentation in this regard is annexure FA1. You suggest the FA1 is the docket. And just flipping through it, it's all about procuring this forklift. My challenge is to bring it within the ambit of section 7(1)(a). This is a forklift on the face of it that cost, or forklifts, and it seems to relate to an acquisition of forklifts, I don't know how many, but for 708,000. Why would IDEC take the investigation into procurement of such? Is that not a matter best left to SAPS? And to the extent that that procurement is flawed, that a process be followed to overturn it?
This arises
Yes, you are saying, thank you.
I think this arises from him saying, Mr. Adams, the siphoning of money from the secret fund account. If you look at the,
Where does it state that?
sorry, Chair,
Like I said, I haven't had an opportunity to work through it.
paragraph 7 of Adams, section 27 referral, talks to the siphoning of funds from the secret service account, a secret fund account
Of the referral, okay.
of the referral.
Yes.
And when you look at page 3504, Commissioners,
Yes, we're there.
for paragraph 5, the supplier unknown to me was paid a deposit securing the delivery of a new forklift. On numerous inquiries, promises were made that the delivery of the procured forklift would be delivered to fleet. Till date, no forklift was received by vehicle management, which was paid for by the use of the secret funds. And further investigation into the matter in order to recover the monies paid. So that is the only place I can find reference to what is said in paragraph 3 on 3497.
Yes.
Read with paragraph 7 of the section 27 referral, and then that paragraph I read on 3504, and that it was looked at because of the use or alleged siphoning of money from the secret funds of crime intelligence. But beyond that, there isn't anything else. That is how I can tie those as having looked at it. And again, bearing in mind that this is an investigation on which no decision has been made yet to prosecute. So it does not mean that anyone, when they are done, will be prosecuted for this, because also from just a reading of it, it is somewhat of a challenge to determine who in fact ought to be held accountable, if at all, for the use of the funds.
I'm not sure that we can confidently say or accept what you're saying. I mean, we've seen what happened with the Mokwele matter, which you have considered. The facts are very poor for the issuing of a warrant, for an investigation, let alone for a prosecution, an ongoing prosecution. So that should be our point of reference, the Mokwele matter. This seems, from what you're saying, may well be one of those cases where charges were going to be preferred. An investigation certainly is happening. Charges were going to be preferred. It would end up in court when, in fact, on the face of it, it shouldn't have happened. And it happens because of other reasons that have nothing to do with the merits or the strength of the case. It's an observation that I want to make in the light of you saying, well, maybe nothing would have come of it. As I'm saying, well, the Mukwele matter teaches us that, well, something can be made out of nothing by IDEC, as it happened in Mukwele.
I hear you.
Thank you.
And then to consider paragraph 4 in the referral, you recall Mr. Adams' suspicion. I suspect that General Kumalo and some other officers in crime intelligence, including Madondo and Lushaba, were manipulating procurement processes and processes to a point. I want us to stop at procurement processes, because this would be one such. When I look at the docket, starting at page 3505, that's the information note for an application for approval, procurement of vehicles, Secret Service Account, Division Crime Intelligence. 3505. If we go to 3510, this would seem to have been signed in February 2023. So that is the information note. Just flipping through it even before I apply my mind to its content, if this is the basis for the fraud charge, I see at page 3509, it's signed by a colonel in the procurement management. It's then signed by finance and administration. At 3510, it's who recommends. At 3510, it's then signed by supply chain management, approved. Then at the bottom of 3510, it's signed by Major General CFO. There is NP Lushaba. After all those approvals and recommendations, he signs, and that's the end. I don't see how General Kumalo and General Madondo are pulled into this forklift acquisition issue. And yet that is precisely the suspicion at paragraph 4 of the section 27 statement. You wouldn't know how. We see General Lushaba's signature as CFO.
And that is to be expected.
Yes. But I don't see anywhere where General Kumalo and General Madondo are pulled into this acquisition.
Correct.
As he said, he originally suspected. And you say investigations are underway around them as well.
This matter is under investigation. I am not, I will go through it like all of you to indicate just from my reading who is the subject of the investigation.
Yes.
Yes. I'm unable to at this glance to say who is, but what is clear is that both the generals that were mentioned are not on the reading. But then to also bear in mind, Council, that we need to get from IDEC the FA2 and FA3, because there was referral made to FA2 and FA3 in one of the statements, and I don't know what role, if any, they play with this matter, or is each thing a separate attachment?
You see, my challenge is you suggest we should get it from IDEC, and we have IDEC before us now.
No, but yes.
Thanks.
What I mean is we've got to get it, because we will be short then, Commissioner Kumalo, in properly applying our mind, because would FA1 just be this, and what is FA2 and FA3? So I will make sure we try and get those as well before the morning.
Advocate Johnson, my reading of these documents, and I must admit I read them very quickly, so I could be wrong, is that there was a proper requisition and it was approved at all levels. The issue is the failure to deliver by the supplier, and the money must be recovered from that supplier because they failed to deliver, but they have been paid. So what is manipulation there? If I order goods because they are required by crime intelligence, and then the supplier gets paid but does not deliver, how does that rise to manipulation and fraud and corruption?
It does not, Commissioner.
Just on those facts, I mean, we looked at 3504, where the person says, is the kernel, says there was a requisition, I was the applicant on behalf of fleet management, I requested a forklift for the unit, an application was completed and submitted to procurement, the forklift was required to move and store accident damaged vehicles. After the processes were complete at procurement, a supplier was awarded a tender. The supplier, that's the next paragraph, was paid a deposit for securing delivery of the forklift. The proof of payment is attached. The supplier did not deliver. And further investigation into the matter must be conducted in order to recover the monies paid to that supplier. So if those are the facts, what is the manipulation of procurement processes and what's the fraud and corruption?
It appears to be simple breach of contract,
It does, Chair.
a civil, not criminal matter.
I take note, Chair.
You agree with Chair or you take note, which is which?
At this part of the afternoon, I agree, Chair.
Thank you.
And then to take it further, just based on the documents as we have them on this purchase of the forklift, is that something that falls within Section 7(1) capital A of the Act? Why is IDEC investigating whether or not suppliers delivered in terms of an award of a tender? You did indicate that it's currently under investigation. My question is, ought that investigation even to have started?
If FA1 is the only document that has relevance to the supplementary affidavit of Adams, on a quick reading, no.
And then, of course, we reach this conclusion subject to what FA2 will tell us, correct? There may be something in FA2 that then brings this, as the chair says, failure to comply with the terms of contract within the mandate of IDEC. And once again, I'll run ahead, and if there is nothing in FA2, what should be the right advice to IDEC as regards this investigation today? And of course, you're working with wisdom of hindsight, I take that. Yeah.
Sorry, I just see that there is, if you, Chair, would you grant me a moment? I see that 3515 seems to be a statement by Fadil Adams.
Yes.
Under a Silverton case, if I would just be granted just a quick moment.
And you want to look at 2 and 3,
Correct.
but then the allegations are directed to General Lushaba. And his failure to
Yes.
take action against the contract.
That is correct. I just wanted to read it. Thank you.
But that statement still doesn't bring us within Section 7.
No.
Yeah.
As this investigation stands, no.
So then my question was, let's assume an extra FA2 will do no better. With wisdom of hindsight, should IDEC today be pursuing this investigation? Is it authorized?
This matter should be closed.
But you did indicate that you referred to your sister agencies?
Yes, what I'm saying is it gets closed in IDEC.
Yes.
But what should happen is it should go back to crime intelligence. It is their contract. It is non-compliance with something they wanted. It's like if I buy a fridge and it's not a fridge I like, I most certainly can't tell council, can you please just go get it changed for me or sort it out? It should go back there.
Yes.
But what does happen is it should go back there, and also to copy the CFO to indicate that there was non-compliance and monies need to be recovered. That is the dual referral that will happen, but it will be for crime intelligence to take action and to ensure the money is recovered.
But why would you even refer if there's no crime? If there's a case of malperformance by a service provider, and that's all there is here, crime intelligence lost money because a service provider did not perform. What is there to refer by IDEC? It's like if SAPS ordered uniforms and there was positive malperformance by the supplier of the uniforms. That's an issue between SAPS and the uniform supplier. What is there for IDEC to refer? IDEC should simply say, we have no jurisdiction to deal with this issue. It has nothing to do with our mandate.
Correct.
I think because the docket is sitting with IDEC, the docket should, it seems to me, the docket should return to its station. I mean, IDEC collected it some way. I don't know whether is this one of those that you got through General Sintumule? If it is, I would say that.
I speak under correction, I will just have to check if this was.
I
one
would
of
say
them.
it must return where it was taken,
Yes.
and they get to do with it what they
Yes.
want to do with it.
Correct.
Thank you.
And to indicate to crime intelligence that we had this, and the docket has been returned, and for them to take whatever steps they deem necessary.
Thank you.
Thank you, Commissioners. The last then statement taken by Investigator Rapesu on my record is at 3493.
3493.
That statement, if we start at paragraph 2, reads thus, and I quote, "On or about early October 2024, I received information anonymously surrounding alleged crimes emanating from the Division Crime Intelligence of the South African Police Service." Paragraph 3, amongst the information, it was alleged that Secret Service funds were used to purchase resources for the political killings task team based in KwaZulu-Natal province. This task team was previously led by the current Divisional Commissioner of Crime Intelligence, Lieutenant Kumalo, who has close ties with the former Minister of Police, Mr. B.H. Cele. Paragraph 4, it is alleged that the resources procured under the banner of the task team were for the benefit of Mr. B.H. Cele and others. We know that our Section 27 doesn't even reference the PKTT at all.
I think you're right.
Remember, it's 5.2, page 512.
His only reference is in paragraph 5, but it is
No, that's a reference to Minister Becky Cele.
Yes.
And that
that's
is
what I'm saying.
regarding his
That's the
appointment
only
of
reference.
General Kumalo.
Yes.
I'm particularly interested in reference to PKTT because he takes 2 paragraphs to deal with PKTT, draws in Mr. Cele and General Kumalo, and even points out that the General Kumalo he's referencing previously led the PKTT. So these are specifically PKTT-related allegations. Now, if one reads Section 27 affidavit as it stands, then short of lunacy for investigator Rapesu, advocate Ramsamy, and Chief Perumal collectively to take a statement regarding PKTT, to call it a supplementary affidavit. If not that, then I don't know. Can you help?
Makes no sense.
Absolutely. You recall in the morning I asked how many Section 27 affidavits there were.
Correct.
And the witnesses that will testify who took these statements are going to testify that the original Section 27 affidavit had allegations, contained allegations against the PKTT, much perhaps, which then makes sense why they take a specific A1 statement regarding PKTT. But we know that our Section 27 doesn't have any reference to PKTT at all. So I go back to my question, how many Section 27 affidavits are there?
The one I have is the 21st of November, 2024.
Okay, I invite us to rush ahead. Let's assume they come in the course of the week to say, no, that is not their Section 27. The real one had the PKTT reference. And if they are steadfast and they are able to persuade the commissioners in that regard, where do we all land? I appreciate you say you are only aware of one. Where do we all land?
That puts us in the same conundrum, commissioners, as where do we land with 3 people saying they were together? Then you have supplementaries to be taken. You have 4 supplementaries by one person, 4 by another, allegedly on the same day. And so if you land with a similar situation.
May I correct you on, and I appreciate the exercise you're undertaking. You've got 4 by one person, and you've got 4 by a team of 3. Because Rapesu and Ramsamy are going to say the 3 of us were together when Rapesu commissioned those statements. So on one hand, the 3 agree these are the statements we took. There is a lot about PKTT. The one lot taken by the one solitary member of that team
Was not taken, that is the allegation that it was not taken on that day.
Indeed, that's the allegation, yeah.
Sorry, I misunderstood.
Yes.
That all happened on the same day.
And
I perhaps misunderstood because they were all dated the same day.
Yes.
Okay.
So the suggestion
Then
is
then that is something that has to be dealt with, because what we cannot have is, it seems, almost parallel processes of investigation, and we cannot have parallel processes of investigation. We're supposed to have one Section 27. If it is inadequate, as I've indicated, Mr. Adams ought to have been engaged, which I believe he was, on the 6th of January 2025. If he was engaged as he was by all 3, then we're supposed to have the 4 that Rapesu took, together with the FA1, which is attached in the Silverton docket. So if they say there is an additional 27, then it talks to how did these other supplementaries come about, still with the same date, and when did that 27 come about?
let me correct you, and to the extent that you may have understood me to suggest that, I'm not suggesting there was an additional Section 27. their testimony, as they have indicated they will testify, is that the Section 27 affidavit we have been sitting with here and working on is not the Section 27 affidavit. The Section 27 affidavit, and we agreed it has to be one, had references to the forklift patches and had direct reference to the PKTT, both of which are missing in our version. So I'm saying there appears to be two when there should be only one, but it's not suggesting parallel processes. You can only have one process. These are members of IDEC, all of them,
Yes.
following the same Section 27. Now, where that potentially lands me is, are we confronted with a fraudulent Section 27? I'm thinking, and I pose that question, if not, how do we potentially explain these discrepancies?
Am I able to ask who took that 27?
I don't know. I promise you I wasn't there.
No, I'm saying in terms of what the witnesses might have provided. Because this one that we have, commissioners, is the one, let's see, that has come from. That was done in Cape Town and I think commissioned by a Ms. Solomons. I'm not sure who would have taken that one. It's important for me to have sight of it if council allows. But I have also only this one.
But who commissioned it surely is not a relevant issue. The concern would be if there are two, regardless of who commissioned either. That's my concern.
Yes,
The
I would-
potentiality that we may be actually dealing with two, the second of which has not been disclosed to the commission.
Okay.
That's the concern.
No, the point I might have clumsily been making was it would help to know if, much like these other supplementary statements, the same person who took them, other than the Rapesu and the team, is the one who took that Section 27, if there is in fact a 27.
But
And
Advocate
that would be
Johnson,
the chief.
do you understand the difficulty? If you look at the supplementary affidavit on 3493,
Yes, sir.
it is dated 6 December 2025. These three people were together in Cape Town on that date. And the simple point Advocate Sillo is making is that on that date, as they were taking this supplementary affidavit, there was only one Section 27 affidavit, and it is not the one that is in our files. It is the one that made reference to PKTT and forklifts and other things.
Okay, so now I
the
understand.
one that we have in our files
Is
is
not
not
the real-
the one they were working on the
Okay.
6th of January 2025. Now, if
Now I
that
understand.
is correct, then it means this Section
of-
27 we are looking at was produced at a much later date and then backdated to 21 November 2024.
I understand, Commissioner.
Because if it existed on the 6th of December, then all three of them would have been looking at this one and not the one that they refer to in the clips.
Understood.
And that is
Now I
a serious
understand.
problem because
Yes.
it affects you as well. It raises this question. The Section 27 you looked at in November or December 2024, which one was it? Was it this one that we are looking at or another one which has not been provided to us?
And this is the one that comes to mind.
Are you sure that in this, you said to ad hoc that the first time you saw a Section 27 affidavit was sometime in December? You said middle December, then you corrected yourself and said before 6 December. Which affidavit did you look at in early December or mid-December? Was it this one or was there another affidavit that you looked at that made reference to PKTT? Are you now no longer sure which one it is.
No, I saw one.
We now focus on
Positive.
content,
Yes.
because an affidavit is an affidavit.
Correct.
The one that you looked at in December, did it make a reference to PKTT and forklifts and other things?
Chair, I honestly,
Are you no longer sure which affidavit?
I
you
cannot
looked at?
remember that I saw that, the forklift and the PKTT.
Say that again?
I cannot recall seeing forklift and PKTT.
But do you remember which affidavit you looked at in December 2024? Are you now no longer certain?
Now that you're putting it to me, I can't give you a definitive answer. I don't know which one I saw. This one is the most familiar, let me put it that way, from having worked with the statement. This has always been the one that has been most familiar, and this is the date I recall.
Because it could be that even the one Mr. Rapeso is referring to also had the same date. So don't focus on the date. Let's talk about the content. What was in that affidavit? Did it make a reference to PKTT and forklifts and other things?
Apologies, Commissioner. I can't recall all that detail.
Okay.
I do apologize. I can't recall all the detail.
No, if you can only give, an honest answer, if that's the honest answer.
I cannot
yes.
recall.
Yeah.
Perhaps, Commissioner.
Ms. Johnson, does it mean your answer now, and you're not recalling, does it mean no one in your team ever said to you, but this is the wrong Section 27? Back then, and when you went to ad hoc and came back, and as you are before us, and as Mr. Parayachi was testifying, does it mean of your entire team, there isn't a single person that said, hang on, we actually had a different Section 27, what happened to that?
No, Commissioner.
No one has ever said
No.
that. Thank you.
I do recall what Mr. Padiachi said about when he had access, but I have no recollection of anyone telling me that I'm looking at the wrong document.
Okay.
Thank you, Commissioners. I recall, and I speak under correction, you did not have the Section 27 affidavit when you appeared before ad hoc. And I think members of Parliament engaged you on the Section 27 affidavit. And if memory serves me well, you parted company on the basis that you'll be providing the ad hoc committee with a copy after you had concluded your testimony. Do I remember well?
I must just go back into the record. I do recall saying I will apply my mind on whether or not we can give them the Section 27. I must just go back. If I said we were going to give it to them, or did I say that we...
They asked you if it's a public document, and you said it's not a public document. And then they asked, can we have it? You said, I don't have it. I will revert.
Okay. Thank you, Commissioner Bala. But I know that we did not make it available. From what I recall, I know that we didn't make it available, Commissioner.
Why not?
Because it formed,
Sorry, it was central to the ad hoc inquiry. And why didn't you avail it?
because it formed part of our criminal investigations.
But you availed it to this commission. Still forms part of the very investigations. On what basis do you draw a distinction?
I understand. I see the work of this commission and its terms of reference somewhat different from the ad hoc committee. And here the rules are somewhat different. And not disclosing is not an option. but you are able to disclose, and perhaps, as we have been allowed in some instances, commissioners, to indicate that the disclosure is also made on the basis of confidentiality for certain reasons. This commission allows us that, and it is on the basis of it having been part of a criminal investigation and not wanting to give it to them.
Okay, we will look through the transcript to remind ourselves where you landed. I hadn't marked it because my understanding was that you had undertaken to provide a copy to ad hoc, but you say you had only undertaken to apply your mind to whether or not you can make same available. I'll have to check on that. I don't have a direct reference at the moment. So, once again, I invite us to accept as correct the facts as we understand them, and of course, subject to other facts coming to light to contradict what we know.
Ms. Silo, can I just
Yes.
ask a question, sir? You've explained the process, how it works. You say there will be, as in this case, there would have been Ms. Ramsame, Mr. Perumal, and Mr. Rapesu as a team, because no one consults alone with a witness, your methods of working. So they would have been together and they would have produced a single statement. Now, if what they say is true, that the only statements that were taken in the presence of all three and the witness are those commissioned
By Rapesu.
by Rapesu, it would mean, what does it mean about the standing of the statements that were taken by Mr. Perumal outside of your way of doing things, but also without the others? What would be their standing?
And it also raises a bigger conundrum because they dated for the same date when he is supposed to have taken them with that team. So it raises its own legal and ethical challenges about why a separate set of statements needed to be taken. They went together for the purpose of taking the statements, and what did in fact happen is Advocate Ramsamy had made extensive notes out of the Section 27, and having read the inadequate, lack of A1s. So she had categorized the questions around groupings of matters to be looked at, aspects to be canvassed with Mr. Adams, so that when they went there, it was a structured approach. So the team should have followed that approach. And if either Mr. Rapesu or Chief Perumal felt that, wait, there's something else still to be dealt with on an aspect, it should have been dealt with all at the same time. If there was a need to, it should have been captured in one document and then commissioned, and then we move on to the next, and so on and so on.
Okay, let me put it this way to you. What I'm trying to get your comment on is, if the three of them together produce the supplementary statements, what has been labeled supplementary statements, the three of them, and then Mr. Perumal, Chief Perumal, behind their backs, because there's no better way of saying this, behind their backs he goes and he decides to write his own statement that he commissions without the other two knowing, and he gets Mr. Adams to depose. Let's assume for now that it is in fact Mr. Adams who deposes, who becomes a deponent. Because on these facts and the mess that has happened here, it seems to me it's not inconceivable that Mr. Adams could turn around and say, but I don't know anything about that, which you say Perumal signed, commissioned. If it turns out that Chief Perumal went and did his own thing, wherever and however, surely the official statement of IDEC would be that which was done by the three of them together and deposed to by Rapesu. Is that a fair?
It's a fair assessment.
It's a fair assessment and proposition to make, right?
Correct.
Okay. Now on that, if in fact, as we know it has happened in the Mukwele matter, if the docket that is before the court and that is disclosed to the accused, and that is the basis for the warrants that were obtained for instituting for the charges, it is in fact Perumal's questionable statements, not the ones that were properly taken. That would amount to. It seems to me that would have amounted to defeating the ends of justice, lying to the court, lying to you, misleading everyone that is involved with this, and failure to disclose the true contents of the docket. Am I correct in all of that? I'm assuming Perumals are in fact a manufactured statement that is being used.
Correct.
That would be correct.
Yes.
Okay.
Because
And that would undermine the prosecution itself, right? The entire prosecution, because it's based on A1 statements that are questionable, as in they've been made up by Chief Perumal, whether with or without Mr. Adams, but they're not an official record of the IDEC.
Correct.
Thank you.
And before we look at what you stated to Parliament regarding providing this affidavit, let's look at how matters were dealt with concerning the contents of the affidavit. I'll invite you to page 554 of file 3. That is your transcript before ad hoc. And if we can take it, yes, Chair.
Including the file with the acts. Which files must I put away? I have
Put
too
away,
many now in front of me.
put everything
6,
away.
a total of 6.
Out of 9. It's 9 files by now. Please put everything away except file 3, Chair.
Thank you.
Except file 3.
3.
We won't need file 2.
No. I'm scared to commit. No, chances are we won't. If anything, but we don't have to go to it, I'll flight it. It is that supplementary affidavit regarding PKTT. Remember, commissioners, we are having this engagement about where the 3 investigators would have gotten any idea about PKTT enough to justify them obtaining a supplementary affidavit. So now we are at file 3. That's a transcript before the ad hoc. It's for the record CJC 375. And in particular, I would like us to go to page 555. And what appears at the top of 555, perhaps 554 is the right place to start, midway, where it says Advocate Johnson. You suggest there that you will deal with the arrest of General Kumalo. And then you indicate from line 2, and I would just for purposes of completeness indicate that IDEC is not aware of these cases that were made, be they by Mr. Matala about theft, by Gatiso Mulefe, the ballistic case, or any other case that has been made against any of the PKTT members. They are not allegations that IDEC is looking at. That was your testimony. But from the supplementary statement by the 3, That can be entirely correct because that statement we just looked at page 349359 is specific about PKTT. So,
I see that, yes,
yes.
yes.
I
wouldn't have seen the wouldn't have seen the supplementary.
I can accept that, but then it suggests that your investigators withheld from you some detail on some of these investigations. From the reading of your transcript at ad hoc, it would appear that you were not even aware that PKTT was being investigated or considered for investigations. I put it no higher than that.
Correct, and that is why when there were the utterances that IDEC was involved in PKTT's business, I was taken aback because, according to me, there's nothing for us to look at in PKTT, regardless of what allegations may have come to the fore.
And if those were the allegations that you are hearing of, now that we have seen the supplementary affidavit at 3493, those claims were not entirely baseless now, were they? That IDEC is, what did you say you had understood, is interfering in PKTT? They don't appear to have been entirely baseless.
Yes, when you look at 3493.
Yes.
Correct.
Okay. Then if we go forward, still staying with file 9 to 656. Page 656, same file 3.
Council, make sure you get us to read the documents that are 4 pages from top to bottom at this part of the afternoon, Chair. Sorry, 656.
It's the best part of the day, 656. And I pick it up from the top. This is an engagement you are having with Mr. Nomvalo. And you had just referenced the affidavit at 655, 22nd November 2024. Then you are asked, do you have it in your possession? You say, no, I don't. Do you not think it was going to be important for you? Then then he states, another problem which I have with your statement is that documents which are relevant have not been attached. He expresses his concern. Your response is no. Mr. Nomvalo asks, would you agree with me if I say to you the affidavit of Honorable Adams is dated the 6th of January 2025? You point out that that would be a supplementary affidavit because follow-up engagements were had by the investigating team with Mr. Adams. And we know that 6th of January correlates with the date on which the investigating team obtained supplementary statements from Mr. Adams. Then Mr. Nomvalo asks you, requests at 656, can you be able to furnish us with the original affidavit to which you state? Unfortunately, that is not a document that I can disclose. This document has not even been disclosed to the defense, and it is one of those documents where even the defense would have to apply for the document to be made available to them. The Section 27 referral cannot be made available, but other documents that Honorable Nomvalo or any other member should have been here. What I would ask is to kindly provide the chair with a list, and those documents that can be made available should be made available to this House in the course of next week as part of a bundle, which would then be referenced according to the affidavit and then be sent to the evidence leader for distribution. Mr. Nomvalo inquires, so is it a classified document? You say it's not a classified document, it's a document that seeks to initiate the intake of a matter. It is a document that, should it be disclosed, will first have to be disclosed to an accused. That document has not been made available to any of the accused. Mr. Nomvalo asks, which law are you relying on to make that proposition? You respond, I'm saying that in terms of process, we have not disclosed the Section 27 referral. It is a confidential document similar to how we have memos in the NPA and not just IDEC. There are certain documents that are not made available for public consideration. You have further engagement midway that page of 657. Mr. Nomvalo states, well, if that's the case, then I'm helpless. I'll put this proposition to you. The affidavit that I have been exposed to is not a supplementary affidavit. A supplementary affidavit is an affidavit that makes notes of the content of the original affidavit and continues with the supplementary content that is contained in the supplementary affidavit. So the affidavit of the 6th of January 2025 is an original affidavit. It was signed by Mr. Adams on 6th January 2025. Now, Mr. Nomvalo seems to have had sight of what is a different Section 27 affidavit. He suggests it's an original affidavit signed 6th January 2025. And for the record, I haven't seen it. I'm just following what is here. In response, you do insist that on 22nd November, we had a referral affidavit. That refers the matter to IDEX and sets out in broad strokes the allegations. Then you have a discussion about supplementation, but it would appear that your position before ad hoc was that you cannot disclose that affidavit to them.
That was correct.
And you invoked privilege as a basis for refusing. Which takes me to understand how this privilege works. You have a specific committee of parliament established to investigate allegations by General Mkhwanazi of the 6th of July 2025. And your entire mandate is triggered by a Section 27 affidavit. When you go account to that committee, why is the trigger affidavit privileged for their purposes and can't be disclosed to them? Which law were you invoking for that claim?
So I would counsel on the basis that this document forms part of a docket. It has yet to be disclosed to anyone, including the accused.
Sorry, I need to interject desperately because I want to make sure that it's not an error. You say Section 27 forms part of the docket. That's not how we got it. Colonel Padiacha says it definitely does not form part of the docket. So, does it form part of the docket or doesn't it?
So the Section 27 is the intake document. According to me, the Section 27 referrals are not disclosed unless they are requested by the accused. Now, when I went to Parliament, we had not disclosed this document at all to the accused. We have not disclosed Section 27's, the referrals, to the defense, because it's the basis on which we initiate our investigations. If we follow the logic that we have been following in the past few days, one has to relook that position because they should be given the full ambit of the investigation and the prosecution. Out of practice, we have not given them that.
Well, it's not just a question of practice. It is what you say. You have a position about it. For example, where Ms. Silo has read, you say to the ad hoc committee, it's a confidential document similar to how we have memos in the NPA and not just IDEX. So you're describing an internal.
As an internal confidential
But it's not
document.
internal. It's not an internal document. It's a document that comes from a complainant. And so to categorize it as an internal document, as if it's an internal document, is misleading. And it's a document that seems, if you're going to disclose a supplementary affidavit, then it doesn't make sense that the founding affidavit would not be disclosed, would be a matter that you ever considered. And when I say you, I mean all of you in IDEC have ever considered that to be confidential and internal, but that which it supplements can be disclosed, or you're obliged to disclose it with the docket. It just doesn't make sense that, especially the lawyers in the NPA and in IDEC would have thought that's okay. You nod. Do you agree with me? Does it mean you agree with me?
Sorry, I'm tired. I agree.
Thank you.
Thank you, Commissioner. I want to move to a slightly different topic, and even the way Advocate Johnson looks at me, I had her comment that I'm tired.
Yeah, no, sorry,
I'm with you.
with my medication, I've been trying to hold out for as long as I can. I do not want to waste the time of the commission, so I do hold out as long as I can. I am just feeling a bit fatigued.
No, I was going to request, I do have some other topics to touch on with you. I see it's 4:10, and it's the normal end time for the commission, and to ask whether it might be an appropriate time perhaps to take an adjournment for the day. Thank you, Chair.
Let us do so and resume at 9:30 tomorrow morning.
Thank you, Chair.
Let's adjourn.